Good evening and welcome to the February 24th proceedings of the Riverside Planning and Zoning Commission. It's a pleasure to have you folks here. As I have remarked on other occasions where we've had agendas as we have tonight and a full house of citizens, residents, I view that as a indication of the vibrancy of our community, and I want to thank you very much for your involvement. So thank you very much for coming. We do have a very full agenda, also reflecting that vibrancy, and so without further ado, would ask Sonia to please take the roll.
Commissioner
Present.
Commissioner Gary.
Present.
Commissioner Lesniak.
Here.
Commissioner Mateo.
Here.
Commissioner Mendoza.
Here.
Commissioner Pelletier.
Here.
Commissioner Randall.
Here.
We have a quorum.
Great, thank you. So first order of business this evening is to approve 2 minutes of this body. The first, the public hearing minutes of January 27th. It's item 3A on the agenda.
So moved.
Motion to approve. Do I have a second?
I'll second.
Okay, any discussion of those minutes? Okay, all in favor of approval? Aye. Any opposed? Abstentions? Okay, approved. Next item, 3B, Planning and Zoning Commission regular meeting minutes of January 27th, 2016. Okay, motion to approve those.
So moved.
Second? Any discussion? All in favor of approval?
Aye.
Any abstentions? Any noes? Okay, motion passes, minutes approved. Item number 4, visitors petitions, citizens requests, and communications. Do we have any folks here who care to speak on items other than those that are in the agenda where we'll be inviting additional comment? Okay. Sonia, would you like to give a liaison report, or is I'm sorry, Doug is in the back. Doug, I'm sorry.
No, it's not.
Okay, thank you. So item 6 on the agenda is a matter of old business regarding subdivisions. Is anyone here in the audience here to participate in that discussion or hear what's going on with respect to that topic? Okay, then at the option of the chair, I think what we're going to do is move that to later in the agenda this evening so that we can deal with the matters where we think folks are here to discuss. So if we can then move to item 7 on the agenda, which is the first, we actually have 3 public hearings under item 7 this evening. The first deals with a map amendment, and so if I will go ahead and bring that public hearing, opening the public hearing for, it's item number 7A in your packet. This regards a, a zoning map amendment affecting property at 43 East Quincy Street. And so what I would first like to do is, do I have a motion to open and second that meeting? We've already opened. Sorry. All right, where's my script? Sorry about that. Okay, so first thing I'd like to do is, as a formality, is read the announcement. Any objection to reading an abbreviated version of that announcement?
I'm just wondering, is this the one that's taken off the agenda? Is
This is
that
the one
correct?
that's, I'm going to ask to continue, yes.
Right, so
Yeah.
we can actually handle all this.
Can we announce that?
Yeah, we can move it.
At the continuation?
Right.
Okay, so then let me explain for the benefit of residents who are in attendance. We had planned on conducting a public hearing regarding this matter at 43 East Quincy Street at the request of the property owner that we received yesterday. He has asked us to continue this public hearing to a later date. So we've agreed to do that, and it would be moved to the March 23rd date. Is there anyone here who came to speak with respect to that matter who would not be able to participate in the meeting on the 23rd? Okay, so we can table it.
Yeah, we just
all
need a
action with
motion and a
respect to-
second to continue the public hearing to the
I'll
March.
make a
Okay.
motion to continue the public hearing to March.
Second.
Okay, all in favor?
And again, it's March
Aye.
23rd.
That was March 23rd, correct? Okay. Any opposed? Okay, so we have moved the public hearing for item PZ 15005 to the 23rd. Okay, may I have a motion and a second to open the public hearing with respect to item PZ 16002, a text amendment to amend the business district uses and definitions.
So moved.
Second.
All in favor?
Aye.
Public hearing is now open. Sonia, would you please take the roll?
Chairman Fisher,
Present.
Commissioner Rea,
Present.
Commissioner Wozniak,
Here.
Commissioner Mateo,
Here.
Commissioner Mendoza,
Here.
Commissioner Pelletier,
Here.
Commissioner Rea,
Here.
Okay, would then like to read the formal notice that appeared in the February 3rd edition of the Riverside Brookfield Landmark. Again, any objections to reading an abbreviated summary? Okay. Notice is hereby given to all interested parties that a public hearing before the Planning and Zoning Commission of the Village of Riverside will be held on Wednesday, February 24th, 2016 at 7 p.m. To consider the proposed text amendment to the Village of Riverside zoning ordinance. And the petitioner is the Village of Riverside. And this deals with amendments to the use and bulk requirements in the business districts, sections 10, 11, 3, uses defined, and the addition of regulations related to the various uses. There's several, section 10.5.9 and section 10.11.3. Okay, Sonia, would or you or Michael, would you care to introduce this to us and what's motivated the village to initiate this request?
Certainly. The village is proposing, well, we've identified several uses that need to be clarified within the code and or changes to state regulations for certain business types that should be reflected in our zoning ordinance. Additionally, staff has received inquiries about certain types of uses, such as driving schools, that do not fall within the use definition zoning ordinance currently has. So the changes proposed will make some regulations more consistent throughout the zoning ordinance, such as art studios, vocational schools, and restaurants. Other changes will address uses that would be categorized as personal service or retail sales, however, are not preferred uses or deemed compatible with the downtown, including tattoo parlors, body piercing studios, junk dealers, or precious metal dealers. Staff is proposing definitions for specialized instructional schools, tattoo parlors, body piercing studios. Staff is also proposing to revise definitions for art or instruction studio, for professional vocational schools, personal service establishments, retail sales, and group ups. So you have those proposed definitions in your staff report. We are also proposing to add tattoo parlors and body piercing studios as permitted uses in the B1C district only. Removing these from personal service definition allows them to be prohibited then in the B2 central business district. Staff is proposing to allow specialized instructional schools, when we have the definition attached, as permitted uses in the B1 and B2 zoning districts. Now, the proposed definition is a school providing classes in driving, test preparation, cooking, martial arts, exercise, yoga, Pilates, or similar uses that are taught for a fee. This use does not include professional vocational schools. So we are proposing to allow those, as I said, as permitted uses in the B1 and B2 zoning districts. We are also proposing to add junk dealers and precious metal dealers as permitted uses in the B1C district only. Removing these from the retail sales definition allows them to be prohibited also in the B2 central business district. And we come to currency exchanges that are currently defined separately from retail sales and financial institutions. However, they are not listed as a use in either the B1 or the B2 use tables. Staff is proposing to allow a currency exchange as a special use in the B1C zoning district only. Then we have pawnbrokers or pawn shops. The state statute does allow municipalities to expressly prohibit pawn shops. Therefore, staff has added an explicit prohibition to our definition, which has also been moved from other terms defined to uses defined. So that will make that easier for that to be found that it's expressly prohibited. We have a copy of the proposed text amendments. So you have the bulk table as revised, so it has the strike through and then the red and underlined are the changes that are being made. And then you also have the uses defined section for your consideration that has some of the changes that are proposed to the different definitions and the new definitions that are proposed. Just noting that the preservation ordinance does state that the Preservation Commission does have to review and comment on any proposed zoning text amendments. So we will be calling a special meeting of the Preservation Commission within 30 days to review these proposed text amendments as well and provide their comments to the village board. So you have before you the standards under recommendation on what you're supposed to consider when proposing text amendments. You have before you the publication, proof of the publication in the paper, and then we have the, as I said, the text amendments on there. As you can see, most of the changes are just related to adding those uses in there for the B1C district. The village attorney and I both believe that it is bad form to mention uses, but then not have them listed or to expressly prohibit uses. So the best case scenario in those was to restrict them to the B1 district along Harlem Avenue or to make them special uses only in that. And then that allows us to then not have them in a different district because we do have a place for them. So we don't believe that the downtown is really an appropriate place for things like a tattoo parlor or a body piercing studio or currency exchange. Pardon me. However, B1 might be a more appropriate place for that. We're certainly interested in your feedback on any of the proposals that we have. If you feel maybe those need to be special uses versus permitted uses, we can have that discussion as well. But those are the proposals we have before you. I guess one other clarification would be that in the creation of that specialized instructional school, we also changed the art or instruction studio to being just an art instruction studio. So that becomes an establishment where classes in arts and crafts, dance, vocal or instrumental music, or similar uses are taught for a fee. This use does not include exotic dance studios or establishments of nude modeling, just for clarification. And then we have the instructional school, specialized instructional school that provides those martial arts, exercise, yoga, Pilates types of uses, along with things like testing schools, tutoring, or driving schools. That is then separate from a vocational school, which is really the only kind of school that we have defined other than your typical elementary school, elementary or high school. So that's what we have before you. I'm happy to answer any questions that you have.
I've got,
If I could just briefly build on this before we get into the questions. Just to be clear, we're not really adding, other than arguably driving schools, we're not really adding anything that can't currently be done. These are all, for the most part, something like a tattoo parlor would fall under your existing code under the category of personal service because it fits that definition. And you just have a few very broad categories in your zoning code currently. And by taking that out, separately defining it, it gives us actually more control over where that is able to be located, because we can say, well, we're okay with that here, but not here. Whereas right now, somebody could come in anywhere and say it's a personal service, I'm allowed to have it. Does that make sense? Okay.
I've got a couple of questions. The one that stands out, jumps out at me that I know nothing about is a junk dealer.
Yeah,
Can
and
you talk a bit about that? Because it's in this, it's in Title 3, Chapter 15. I guess I could have looked that up, except my laptop's on the blame. We didn't get any text on it. What is it? And at least, can't we at least make it a special use rather than permitted, or?
We certainly could do that. Junk dealer typically is defined in our ordinance as somebody who is gathering things that they're not necessarily buying for a fee and then trying to resell them, but not trying to repurpose them. So,
Right,
you know,
so,
they're not trying to get a bike that's broken and fix up the bike and resell it. They're just trying to sell you a broken bike or a broken coffee maker or
So the other guys I see in front of my house on Thursday mornings bringing through my trash.
they might be, or they might just be recycling.
and the only reason we dealt with junk dealers is you have another section of your code that's been there a long time on secondhand dealers that breaks things down into junk dealers
Versus a secondhand dealer.
versus secondhand dealers versus precious metal dealers.
Versus
And,
antique dealers.
and so again, we wanted to just say, okay, well, these are already defined and in here in this part of the code. Our zoning code should match up with that. And we should say there's this whole set of regulations for those secondhand dealers in this 315.1. So we just have to say where they can and can't be.
So, in other words, all the other secondhand dealers that are listed in 315 would qualify for being in B1 or B2. Because they're not explicitly called out in B1 as, and eliminated in B2.
Well, I think, yeah,
Suggested retail sales establishment to say that it does not include junk dealers or precious metal dealers, but it does include secondhand dealers as defined in that ordinance. So that would be okay, and an antique dealer would be okay, but we're specifically pulling out the precious metal dealers, which would be like the cash for gold, and we're specifically pulling out the junk dealers and say those are not necessarily something that we want in the downtown, but perhaps that's something that could be allowed on Harlem Avenue
Or Ogden.
or Ogden, right around the corner of Ogden. And then we proposed the special use for the junk, or did we say permitted or special use for?
Permitted.
We did do permitted? Okay.
Yeah.
So we can change that to special use if you feel like that's more appropriate. I can see that because there is a possibility of outdoor storage, and so we might want a little bit more oversight of that and put it in as a special use would seem appropriate as well.
Well, since on Harlem, some homes back up to them, so if there is a lot of outdoor use, that
There could be.
might be better as a special use.
Mhm.
So moved.
Okay, so we have that. So is there consensus on that change? Okay. Any other comments?
Yeah, the other question I had is we removed the word restaurant from brew pub. Was that intentional, or is that covered up, again, somehow covered under Title III, Chapter 2?
That is somewhat covered under that. There's been some changes to the state liquor license requirements, and they've kind of broken out craft breweries from brew pubs, and they've removed the restaurant requirement portion for brew pubs. So they are not requiring that you have to have a restaurant in order to be a brew pub. So we're trying to match more closely what the state requirements are and referencing that. So it'd be more similar to the requirements for a craft distillery. They've made it more in line with those.
Okay.
So it could be an either or situation.
So 321 would be changed if the board adopts this change, right?
Right, and the board would also have to adjust the liquor license class definition for brew pubs to mimic that language.
I have a question regarding the pawn shops. Does Title Max fall into that category since you're putting the title of your car up for a short-term loan?
Arguably, they might, under this definition. This definition we found in an odd place in the code, and so we're bringing it over here. It wasn't a defined use the same way a lot of things are. So we're bringing it over here, but, Title Max is an existing business,
Sure.
so they would end up being legal.
I was just curious about that definition, if that would actually qualify or if that's somehow
I think
different.
It might, yeah.
the only other question I had, referring to the arts instruction studio. As a person who had life drawing as part of my art education, the prohibition against nude modeling for such purposes.
Yeah, I think that's long been in the code.
I understand. I'm just curious.
Yeah, if you think, yeah, that's the sort of thing we can talk about, if you think it might be appropriate to take it out.
Well, I question whether it should, because there's a long tradition and history of that as part of the education of artists and life drawing. I mean, I understand the exotic dance studios, but that's a very different type of subject matter.
Yeah.
So.
So how would we deal with that kind of comment? Are we as a body comfortable with making it? So where in the code would that be stricken from?
In the definitions, so under 1011-3, under uses defined, at the very end of that definition of arts instruction studio, it says, this use does not include exotic dance studios or establishments with nude modeling. And so we would strike out or establishments with nude modeling. If you want to, after some discussion, if you want to make that recommendation, that would be what you would be asking to strike.
Yeah, we're really that worried about it.
Actually, I think more of my concern is that you've changed the definition from arts or instructional studios and just made it art instructional studios. So that really means that I can't be an artist.
Well, we have a separate definition for art gallery.
But that's a gallery. I'm talking about somebody that is actually, could be producing their art in a space and selling it. I wouldn't necessarily consider that a gallery. So my concern is that you're eliminating something that I would
Let
be
me go grab that
totally against.
definition real quick, and we'll double check what it says in there, so we can make sure we're not overlooking that.
Okay, so we'll come back to that item. Any other questions, comments?
Can I ask a member of the audience, but Charlie, are you on the board of the art place? No, you're not. I was just curious if you were and if there was any history of having life drawing. Okay, thanks.
I had a question wanted to ask staff and Attorney Mars what the rationale was behind proposing that currency exchanges be a special use and precious metal users be a permitted use. I guess one way of thinking about that is they're similar businesses and would be similarly classified in the table.
I'm sorry, could you repeat that?
I'm sorry, Sonia. Yeah, I'm looking at the proposed classification of currency exchanges and precious metal dealers. And I guess maybe the way I'm wired is I'm kind of thinking that from a business intensity standpoint, the kinds of things we might be looking at in this table, that they would be similar. And so I'm curious why the currency exchange is proposed to be special use and the precious metal dealer is proposed to be permitted, as opposed to making them both permitted or both special use.
Let's see.
I think part of the rationale is that, we have enacted a separate set of regulations that govern the precious metal dealers, reporting requirements, security, at the time we were talking about a cash for gold coming to town, we enacted a set of regulations. Whereas the currency exchange, there is quite a bit of state regulation of those, but
We don't have any specific.
we don't have
separate
specific
licensing
regulations.
requirements for that.
Okay.
But that, you know, again, these are just put out there for discussion. I think it's perfectly fine to make precious metal dealers a special use.
I guess I'd be in favor of that.
Second.
Prevailing.
Everyone good with that?
Okay, so then let's briefly return to the issue that Commissioner Lesniak raised with respect to the art or instructional studio.
Currently, the arts or instruction studio reads as an establishment where classes in arts and crafts, dance, exercise, martial arts, yoga, Pilates, or similar uses are taught for a fee. So it doesn't really talk about it just being used as a studio in that definition to begin with. Then you have art gallery. Art gallery definition is an establishment engaged in the sale, loan, or display of painting, sculpture, or other works of art. This does not include libraries, museums, or non-commercial art galleries. So we don't quite have one that actually addresses just using it as your own personal studio. So we can try to incorporate that into the definition of arts instruction studio.
That would be something that I think would be good to have.
Mm-hmm.
It probably should be a separate definition, though. You're not going to be in there teaching anything for a fee if it's a true studio, which is what this paragraph seems to address.
I guess it would depend on whether they had apprentices or not.
And if it's an art studio, how does it really differ from an office? I mean,
I don't think
is
it
it
does.
not right? Is it not covered under some other general definition of whatever, an office space or?
Professional office, though.
Is an architectural office different than an art studio?
It falls under the professional offices.
Yeah,
I guess it would depend on whether, you know, if it's an art studio and they're doing sculpture and they're doing heavy metal sculpture and welding and got lifts and everything else, or smelting, you know, those are issues that maybe we don't want downtown. But,
No, this has.
you know, dust from sculpting stone, and, I mean, those are things to look at, I guess. Arts aren't just painting and clay.
An art studio could be the same thing too.
It's true.
You can be. See, the way I understood the definition, or the way it seemed to imply arts or instructional studio. So it's like art studio or instructional studio. So that one, it seemed to fall underneath at least somebody can have an art studio, versus if you just change it to art instructional studio. Now, that takes, to me, that takes out the fact of somebody having an art studio.
Just put arts on
The
it.
original
So are you proposing then leaving the word "or" in there?
Well, that or changing it how it's worded. I understand that they want to take out the definitions of exercise, martial arts, yoga, Pilates, and so forth. I just want to make sure that we're not eliminating potential artists.
But the original definition was arts or instruction studio, and it both included are taught for a fee. That was in the original definition, so I think there's a sort of an inconsistency here. In other words, if we use the or, an arts studio for a fee, well, if it isn't instructional, what the heck is it that you're charging a fee for? Coming to see the nude modeling?
I'm just thinking that it needs to be defined.
Yeah, no, I agree.
And it's not a matter of, what I want to do is just make sure it's not eliminated.
Right, so I think maybe the best approach would be to separately define art studio and make it a permitted use.
And you can leave that as it is, which would be fine. And I do want to go back to brew pub.
Okay.
Now, the definition here, this is only where he can only sell his craft beer? Is that the way a brew pub is defined, or can he have other craft, theoretically, other
They
craft
can
beers?
have other craft beers as well for the state liquor license.
Okay, this one here was a big debate going back a long, long time ago when we were doing the zoning code. And the whole idea of requiring food to be served at an establishment, of not having, basically, what this would be is a upscale bar, really, if you want to call it that, because they're brewing their own, or they're brewing, now, not that I'm against that, but I'm just wondering, because, just so the other commissioner know that when we did have this discussion, that was a big issue of having a place without food or with food. So. And I just want to make sure everybody understands that that was an issue before. I want to be clear that I'm not against it, as I was before.
Comments on that, on Commissioner Lesniak's point?
Well, is this change just keeping pace with the state law changes?
It's that, and we have had a couple of inquiries about people looking to open brew pubs in town.
Okay.
The distillery,
With or without providing food service, we've had both.
And earlier you said the difference between with food service, without food service, it's now a brew pub. If it has,
They've no longer made it a requirement that to be a brew pub, you have to provide food. So in the state licensing, you don't have to serve food. You can just be producing the beer to serve at your,
okay.
at
They
your
changed the
establishment.
definition.
And they
The definition before required you to have food only.
Right.
Gotcha.
So as the craft beer industry has taken off and home brewing and craft breweries have taken off, the legislature's been changing this law almost annually to do different variations to increase the amounts that these places can sell and distribute, as some of them have really been successful and grown. And, so, but the fact that the state now allows you to serve craft brews and bring in outside brews as well without serving food doesn't mean that we have to in Riverside. But, because there have been inquiries, wanted to have the discussion.
And we still have the liquor license class, so we can say it in the zoning code, but if they choose not to, revise the liquor license class to remove the requirement for serving food, then.
Right, the difference between this and a traditional tavern is they are required to actually brew some beer there. It's part of that's their business model.
So
Not
that
ex-
is, that is
But they can sell not
required.
exclusively
Yes.
their own, they can,
Right, so this doesn't just generally allow somebody to open up a place to serve craft beers without
But they
serving.
have to buy it from a licensed distributor, they're not allowed to just, run over to Riverside Foods and buy a six-pack of something else to serve the people. They do actually have to buy it from a licensed.
But they still have to brew on site.
And they have to brew on site
Yes.
their own beers.
okay. So this proposed change is essentially trying to keep our ordinance in step with state statute, yes?
Right.
So are we comfortable then leaving it as proposed? Okay. Matter of order here, we very smoothly transitioned from staff comments into our discussion. So what I'd like to do at this point is just invite public comment on what we've just talked about. Is there anyone in the audience who would like to come?
I have
Okay.
two witness forms here. If anybody else wishes to speak, we do have forms over there. If you could fill out your name and provide it to me, and I'll call your names to come up and speak. We've got Michael Murphy.
Now, may I ask all of you who intend to speak to be sworn in? Sonia, could you please
Yes, can
swear
you
everyone in
raise
all
your
at once?
hands for me? Do you swear the testimony you
If you would be kind enough when you come up to the lectern to provide your name and address, please.
Great. My name is Michael John Murphy. I live at 64 Lawton Road, just down the street. I want to talk about a couple of things that are in this section. First, right on the brew pub definition. I think it's really easy to say, if you're serving food and you're brewing beer, that's the sort of business that we want to see. I think we probably should look a little closer at people that are brewing beer and not serving food. Is that always going to be a good idea? I think you probably need to consider taking that under the special use end of things, so that each time it comes up, you look at it and say, hey, is this what we want to do here? Right? I mean, are they blanket? Is a brew pub that's not serving food a blanket good idea? Right? I mean, I can see there are a lot of people that are doing this. Our friends at Buckle Down on 47th are making a really good living at this. They don't serve any food. There's another one on East Avenue. They're not necessarily bad, but I think in a village like this is basically a residential village. I think you need to look at every time you're opening up what amounts to a bar. Is that the right place to put a bar? These are all good developments, but it's not necessarily, yes, check, this is what we always want to have in all places. Which gets me to the second thing I wanted to really talk about, was the change in the mixed-use peripheral zoning that is going to allow restaurants without being necessarily special use. Again, these are areas that are in the transition from residential to commercial areas. They're there for a reason, because not every type of development is good at that edge, right? We're talking about places that are surrounded by single-family houses for the most part. Every one of these isn't necessarily, again, appropriate for a restaurant. It should not be an automatic right that you can stick a restaurant up against residential areas. You should actually, every time it comes up, take a look, run through the process and say, yes, is this the right spot? I can think of a couple places where it might be a great idea. I can think of a couple places where it needs to be examined before you go through and do it. It's not that restaurants are a bad idea, but you don't want to just say, blanket, these mixed-use peripheral zones that are set up as a buffer between residential and commercial areas are not necessarily always going to be appropriate for that kind of use. I think it's something that, this isn't going to come up a whole lot. We're not talking about 37 guys coming in here to ask for a special use permit for restaurants. It's a handful of people, a handful of uses. They ought to have the courage of their convictions to come and stand before the board and say, this is why I want to do this here, and allow people who live in the area to come up and say, this is why I don't necessarily want them to do it, or I do want it. It's open for a lot of interpretation. Those are the two basic points. The rest of, I'm not up here to talk and behavior of pawnbrokers. I don't think we really need that around. No offense. Oh, and I agree with Mr. Randall. Live art drawing is a fine thing. We shouldn't be prohibited legally by right. I mean, again, that's a good thing. People are learning skills. That wasn't on my intended agenda, but it came up. All right, thank you very much.
Thank you for your comments. Thank you.
Hi, my name is Jane Murphy. I'm from 64 Lawton Road, Mike's wife, and he and I jointly own the house there. The points that Mike made really are the ones that I want to make. There's nothing that the change in the Illinois law, at least to my knowledge, requires you to change the definition of brew pub. I think that it's something that the board should take the time to look at in individual cases and decide if that's something that is the right thing in the right place at the right time. And then secondly, the same issue with the change of restaurant without a drive-through. I noticed that in the peripheries district, it's changed from special use to permitted. Again, that's something that I would suggest that the board would want to look at and confirm that it's part of what the village's plan is, and that at least somebody thinks a little bit about the people whose houses back up to some of these uses. I saw the board do that with respect to the houses on Harlem, and I would hope that they would do the same thing for the other people in the village. Thank you.
Thank you for your comments.
Can we ask questions?
Sure.
I've got one more. Oh,
Okay, the others first, or
Okay.
should I ask, or do you want to? Now, you back up on the property that it's been continued, we're gonna be discussing it next month.
Right.
And I noticed you have a play set in the back, so I presume you have very young children.
They're
that-
not that young anymore.
All right, well, then maybe anticipating grandchildren.
We have freshmen in high school and sixth grade.
Okay, is there any fence or other obstacle device that could be inserted in there that would make you more content with the situation, or?
Are we talking about the proposed use at 43 East Quincy?
Because we should.
Yeah,
I mean, that's
That's
probably
been
something
continued.
that, I mean, we can talk about it.
Yeah, we'd like to give you your thoughts on that.
I got a few, but I understood that we weren't supposed to be doing that tonight.
Yeah, I think the intent is to consolidate that discussion at the continued public hearing so that we can receive them in context. So,
And that's fine, and we'll be back.
great, thank you. Okay, anyone else wishing to speak on this topic?
Well, let me ask a question. Is your concern like the deletion of the restaurant portion of the definition, or is it the status as a permitted use versus a special use?
I think it's permitted, I wouldn't want to rule it out. I mean, there are places where it's potentially appropriate. You don't want to ever say no necessarily, but I don't think it should be permitted by right. I mean, anybody in this zone can do this.
And what's important here is that we're not just looking at our property, you're making a change to the entire zoning code.
Right, but my question is, do you care at all about the deletion of the need for a full-service restaurant, or is it really more the use status?
Both, because the full service restaurant versus not has more to do with, are we setting up a bar?
Right.
What's the nature of the company that's coming? Is it something that's appropriate for the village? This village should have a higher standard than the state of Illinois regs. No offense, I mean, we ought to be here rather than, lowest common denominator.
Mr.
So I
Murphy?
think you want to have.
Mr. Murphy?
If I could ask you just to return to the
Sure.
podium for the discussion, I appreciate it, thank you.
No, to reiterate, that issue, the part about separating the bar from the brew pub, has more to do with what's left becomes more like a bar, and is a bar appropriate in all places. The proposed change says a bar essentially could be appropriate in all places, and I'm not sure that that's a standard that I'm comfortable with in my village. Bars are fine. I have enjoyed a number of them over the years. But I just wanted to say that, that we should take a closer look each time that sort of use comes in. I think it's fairly easy to say, if I'm brewing beer and serving food, that's probably the sort of thing that we want to be doing. I mean, that's a higher standard, if you ask, in my opinion.
So if the definition would remain as it was with the full-service restaurant language in there,
Yeah, that
would it matter to you then whether that it was a permitted use
Does the
as
current-
opposed to a special use?
No, I think that if I understand it correctly, could I come, let's say I was a craft brewer, and I've been known to brew my own, so I suppose it's a career option. But if I came in as a craft brewer and said, I want to set up, under the current standard, if I want to come in and set up a brew pub that does not serve food, is that an option? Can I get a special use permit to do that under the standard as it sits right now?
Not currently.
Not currently. See, I'm not sure that I would say you should never be able to do that. There are lots of examples of that being a very successful operation. I don't think I would say, no, you should never do that. I think what I would say is the village ought to take a close look before they say that that's okay.
Okay.
So I think that probably pushes me toward special use. I'm sorry, I don't have the terminology, this isn't my.
No, I understand. I just wonder how important that language, the deletion of the language, is that what caused you concern, or was it the change or the status as a permitted use?
Yeah, I think it's probably permitted use as opposed to it's generally a bad idea and we should never do it.
Okay.
And then, the location issues. So while I'm standing here, anything else?
Thank you.
All right, thanks very much, guys.
I would
Thank
just want to clarify really quick that for brew pubs, they are currently permitted in the B2 retail core, and they are not permitted in the B2 mixed use periphery or the B2 public use zone. And then when you go to the B1 district, they are permitted in both, or they are permitted in the B1C district, and they are permitted in the B1 TC, or transitional district. So they are not permitted in the mixed-use periphery at all. We could put them in as a special use if we wanted to. We're not proposing to change it from being permitted in the B1, either in the B1 sub-districts or in the B2 retail core district at this time. If that's something the Planning and Zoning Commission wants to entertain, we can discuss that further as well.
Well, and with that come, again, that periphery zone is a buffer zone. These are uses that need to be looked at close before you start setting them up in that buffer between commercial. Downtown is a lot more wide open. The edges where people live, it gets to be a little bit of a different story. So I would say that the periphery zone again needs to be one of those places where you look close and you don't just automatically say barred.
Great, thank you.
All right, and then we have Jim Dennis.
Hello, I just wanted to introduce myself. My name is Jim Chance. I am not a village resident, but I am hoping to, I applied for a business license in the area, and I'm here because of the proposed amendments to the zoning. I'm the owner of Payless Driving School. This is my partner, Thomas Machka, and we are hoping that the proposed amendments do get changed so that we can do business in the town. And I was just here to if you guys had any questions or anything like that.
Bill, thanks. Thank you. Great, thank you.
Come in.
Thank you. Okay, Attorney Morris?
And just specific to driving schools, when these gentlemen approached staff about possibly locating a driving school in the village, we couldn't find a definition that would allow them at all, which is part of the motivation for doing this.
Yep. So they would be considered under the specialized instructional school.
In that section, I have a suggestion.
Okay.
I think we're missing a comma after test preparation.
Yes, thank you.
Thank you. Driving school in Riverside, it's perfect.
Any questions or concluding comments before we close the public hearing and then transition into our final discussions?
I have one question for the driving school. Do you guys maintain your own fleet of cars, or
Yes, we do.
where would they be located?
Well, I'll be honest with you, at the location we have in Palos Hills, our current location, we have 2 vehicles. In the beginning, when we open up, when we open up the new one, we'll be using those 2 vehicles in addition, or with this new place. Those vehicles will be located in Palos Hills, kind of where we live. I'm also a teacher at Warren High School, so basically I'm going to come to work every day, and then afterwards is when we generally, everyone that we hire, or most everyone, are teachers, so we do after school driving, and then we do weekends. As of right now, we do not have any plans of keeping the vehicles in Riverside. Now, if the business expands where we need, several cars, then, we're going to have to figure out something. There is a location behind the business. We're talking about 3238 South Harlem, where they have 1 parking spot available. From what I have been told, when we were looking at different locations, there are several businesses in the area, like the gas station that's down the block. They said that sometimes they may run out of parking space or something like that. But as of right now, we do not have any plans to have a vehicle at the location. Safe.
Or the bank or vault that's across the street from us. I was going to approach the guy and see if there's a way to keep, maybe rent a space and keep the car there.
But Well, it wouldn't be on the street anymore, or anything like that, taking up spots.
Thank you.
Okay, then may I have a motion to close the public hearing on this matter?
Make a motion.
Second.
All in favor?
Aye.
All opposed? Sorry. Didn't give you the opportunity. Okay, so then let's try and finalize our discussions on this. So I've made a couple of notes along the way. Maybe we can just take them one at a time now. Let me just clarify with Sonia and with Attorney Mars. Is the intent here that we go through, we provide you clarity on our feedback, and then this is advisory to, this is gonna go back to preservation will then
Well,
review
preservation
it?
will also review it,
And then it
but
goes
your recommendation is to the village
to the
board.
board. Okay, great, okay. So the first one I noted was with respect to junk dealer.
Can I make a suggestion? Why don't we go down through all of those that have been changed, and then look at those individually and make sure everybody has the same consensus instead of bouncing around.
Okay,
Okay. Start at the top.
then Sonia, you wanna just go through it?
Body piercing studios, permitted use, B1, C sub-district. That's the commercial retail.
Maybe, you know what, so, I'm sorry.
Uh-huh.
For the benefit of everyone involved, can you just make sure, can you define B1C and the transitional zones so everyone
So
knows
we
what
have
we're talking
the
about?
B1C commercial sub-district of the B1 zoning district, and that is for retail uses. And then we have the B1TC, which is the transitional commercial. This is supposed to be more geared towards office uses and providing that transition into the residential areas.
Thank you.
Then you have the B2 sub-districts where you have the retail core, which is more what's along Burlington and a little bit along Quincy Street, and then along Forest and East Avenue, making that little triangle there. Then you have the mixed-use periphery, which is the extended part of Quincy, after you get past Metal Mites. And then you have the public use zone, which is basically the public buildings in the downtown. So those are our districts that we're looking at. Those are all of our commercial districts.
So B1C and B1TC are primarily along Harlem?
They're along Harlem, a little bit along
TC.
Burlington.
TC is only along Burlington.
Right, Burlington, that stretch that comes in where,
Right, we have a lot of the medical offices and
Okay.
stuff coming down Burlington from Harlem. And then along Harlem, you have the B1C, and then you have along Ogden, coming around through McNeil, professional building, and the other office building there. It's also B1C.
Okay. Thank you.
Okay, so then if you'd like to just take us through the list and we'll
So we've got body piercing studios added and listed as a permitted use in the B1C, and then not permitted in the B1TC,
Or in B2.
or in B2 at all.
Well, we're gonna, are we, okay,
just the
Just
ones
in
that
general,
were
so we'll
changed.
take that use
yeah.
and run with it. Anybody have any objections to it being permitted? Do we think it needs to be a special use?
It's fine, I mean,
Okay. Currency exchange, we had listed as a special use in the B1C, not permitted in the B1TC, and not permitted in the B2 district at all. Seem acceptable?
yes.
Yes. Okay. Next up, we have junk dealer. We have that listed as a permitted use in the B1C district only. It would not be permitted in the B1TC district or in any of the B2 districts.
This one I'd like to see as a special use.
Yeah.
Yes?
Yeah, I think the consensus are.
That was
Yes.
our consensus. All right, so move that to special use. Precious metal dealer, we have as a permitted use in the B1C district, not permitted in the B1TC, and I believe not permitted in the downtown.
And we have one already, don't we? That's on
Right.
Harlem, that's on Harlem right now.
Yes.
So, yeah, I don't have a problem with it being permitted.
Anybody else? Okay. Next, we have tattoo parlor, listed as a permitted use in the B1C subdistrict, not permitted in the B1TC, and not permitted in the B2, in any three of the B2 subdistricts. Sounds okay?
Sounds
That's
okay.
fine.
Okay. Specialized instructional school, we have added as a permitted use in the B1C and the B1TC, as well as permitted uses in the B1 retail core and the B1 mixed use periphery. Apologize. Okay?
Yes.
Okay. And then we have,
So,
yes,
just to clarify, the library does not allow people to tutor for income, is that right? Does anybody know? I don't think they do, but that would be in the public zone, and that would be a specialized, well, it's not a specialized school. Just trying to make sure that the public zone
no, I
doesn't
think,
already
I think
have.
if it's, people are meeting at the library and studying, I think that's allowed under being a library.
Right, and I think they have a prohibition on people getting paid to tutor
Right.
in there.
That's like an internal policy.
Yeah.
Mhm. So next we move into some of the new changes that are for the B2 districts. And the first one happens with restaurant without drive-through facilities.
This one, I'd have to say I agree with Mr. Murphy.
I do
I'd leave it as a special use.
You would leave it as a special use? Now,
I
I will
would
just
agree.
outline the reasons staff looked at changing that to permitted is that we do allow a restaurant with an outdoor cafe as a permitted use. And so just a restaurant without a drive-through as a special use seemed a little off course from what we were allowing with a restaurant with an outdoor cafe. So for consistency purposes, we felt there was probably more impact with a restaurant with an outdoor cafe versus a restaurant, or just a regular sit-down restaurant. So that was staff's thinking in that one.
Or maybe we should go the other way. So, make the
But-
restaurant with outdoor cafe a special use. I mean, if we want to be consistent, but stick with the concerns about it being at the periphery between residential and commercial.
Anybody else?
I don't see this, that much similarity. I mean, I think they're two quite different clienteles that you're dealing with, and I would just soon leave it the way it was.
I would have to agree with you. I guess I understand, yeah, they are basically almost the same thing. They're both restaurants.
They're both restaurants, just one would have outdoor seating
Seating.
as well. So that's bringing people outside, whereas everybody being contained inside. Why is that a special use? So that was where staff was coming from on that one. Policy decision had already been made to allow a restaurant with an outdoor cafe. Perhaps it was overlooked looking at the fact that restaurants without a drive-through were a special use.
Yeah, I guess I
So-
would think the outdoor cafe would have more of an impact on a residential situation if it was next door. Because you're gonna have people talking at brunch on Sunday morning while other people are trying to sleep in, or late at night till
Correct.
10 o'clock. And so I think if we were gonna try to clear up the consistency, changing the permitted use at the periphery for the outdoor cafe to special use would make more
And
sense.
keep them both special uses?
Yes. Yeah, I think at
Would
that
that
point,
make-
keep them both special use. This way they're consistent.
Anybody else have any feelings on that? Does that sound okay with everybody? Making them both special uses?
That's just for the mix. That's
In
just
the
for the
mixed use
periphery,
periphery,
right?
correct.
Periphery at the
Yeah, that's fine.
Yep.
Okay.
That would be permitted for both, just for the record.
Should we do a roll?
I think I'm already outvoted.
Alrighty, the next one is, we went over school specialized instruction. The next one is art instruction studio. For some reason, art instruction studio was not listed in the B2 district, so staff is recommending that be added as a use under the B2 and be added as permitted in the retail core as well as the mixed use periphery.
And then how would we address the art studio? That go underneath the same category?
Yes.
Yes.
Mhm.
So all
So
we
you
would
would
need to
add-
do is find a definition
And then
Craft
add
a
a line
definition.
as permitted use.
And we would like that as a permitted use in both the retail core and the mixed-use periphery.
Well, I would say yes.
And then, same thing for the transitional, or for the B1. So I think we have them listed under B1 as well.
Well, I guess, well, I guess it would, for me, on the art studio front, I guess on the periphery, the mixed use, that might warrant a special use, because if they're a stone sculptor, there's gonna be a lot of dust flying over into their neighbor's yard, which could be a
I'm
residence.
fine with
You know what I
making
mean?
a special use on it.
Yeah.
I mean,
As long
Richard,
as it's there, that allows somebody to potentially.
sure. I think just on the periphery, that mixed use, that we should probably find out what kind of art studio it is and look at it from that perspective.
What's the fee for special use? Yeah.
I believe it's $1,000 for commercial special use.
And for a small business, that's a lot of money.
Well,
That's-
could that be waived?
that's
I mean,
just-
can we waive that for,
They would have to request the village board.
right, but it could be waived if, under those circumstances, if they applied for.
But if you're sitting at your laptop at home and looking at various village codes, you might not know that that could happen or is even an option. You might look at another village.
Because
I mean, if it's
I
inside.
just want it inside the code that we allow it. I'm willing to go either way.
What if in the definition of art studio, we specify that, what are the concerns you have about,
Well, if it's,
other
Well-
than metal studios or
well,
something?
metal or stone sculpting, I mean, that's, I've been in facilities where they're carving stone, and that's a messy business. I mean, there's dust flying everywhere. Like, we're to the point where they're wearing respirators and things of that nature, and the notion of that parked next to a residence, I think, would be a little disconcerting.
And those, and that, those type of businesses that you said that you were in, what were they fabricating?
Various things, some were doing sculptures, some were doing building stone, some were doing carvings, like the pieces that would
So
go
you're
on the
talking
top.
about a fairly big production?
Not necessarily, I mean, like,
If I
the
had
s-
some- if
the
I-
stone
let me
carvers.
finish. If I
Sure.
had somebody doing building stuff, which is probably a lot, and somebody doing sculpture, and somebody doing something else, you've got to have a fairly big facility to start doing that with the type of materials that you're having, that you're pulling through it, the cranes, everything else that you're going to need to move the material. I mean, the intent here is that we don't have any facilities that large that would be pulling in that. What I'm faced with here is just wanting to have the ability to have art studios in the town
Well, sure, I would
without
agree.
putting a bunch of caveats on them.
In the periphery. Mixed use, right. Can you put a
Anybody else?
star that says no stone cutting?
Yeah, is there a way to control the noise and the,
Well, I mean, we have
Yes.
the comprehensive set of noise regulations
Mhm.
that would, you know, and I think usually in our use standard, general use standards, there's things about the creation of dust and those sorts of things as
Okay.
well that we could use as enforcement tools in the event that one of these was creating a nuisance.
Okay, well, as long as there's ways of controlling it, I don't have an objection.
so then it sounds.
That's just
the-
my only
The prevailing
concern.
thought then is to maintain those as permitted, yes. Okay.
So we would add art studio is permitted in both the B1, or B2 retail core and the B2 mixed use periphery. And staff will work on a definition for that to present to the village board.
And they would also be then in the other ones, the 1C and the
The
1TC.
B1, yes, we would add to the B1 as well.
Okay.
Mhm. So after that, we have the definitions. So that's the last of the use changes. We have the definitions. You made your comment on adding an art studio definition. And everybody is in agreement of that. We have the body piercing studio definition. Did anybody have any changes to that? Okay.
Yeah, I don't know that we need to go through all these individually unless someone has any particular comments.
So we have the brew pub comments.
Yeah, the only-
Anybody have any?
We then sort of moved the discussion to those things that staff didn't address, which residents have brought to our attention at the bottom of the.
I think that the brew pub is one that we have because it's changed the definition has changed the idea of what the brew pub was when we originally had it in here as. And I'm just wondering, and this is, I'd like to have this as a discussion to say, what does everybody think of having it as a permitted versus a special use if the brew pub definition now changed from having food to just serving craft beers?
We can even
Thoughts?
separate it out if we wanted to and have brew pub with full service restaurant and then just brew pub without full service restaurants. Like we've done drive-throughs with or without drive-throughs,
So you'd basically create a brew pub as a special use and a brew pub with food as a permitted use.
which is basically what we currently have, and then we would be
Right.
adding brew pub without food
Right.
as a
As
special use.
Yeah, I'd be comfortable.
regardless of district.
Yeah, I think so. I think in terms of, be it that it's a special use, it gives us the ability to say, I don't think this is a good choice.
I'm just gonna put a little bit of pushback there,
Okay.
and we have a craft distillery,
I
and
know,
we allow those as permitted uses.
In the periphery?
No,
No.
Okay.
they're retail for.
In the retail court. And they're permitted uses in the B1 as well. So we have a craft distillery, does not require them to serve food, and they are permitted use in the retail court. So if we're gonna start saying that a brew pub that doesn't have a full-service restaurant needs to be a special use, then we might need to be addressing.
okay, so
that
we're
as
basically saying the same thing, that it would be in a retail court. But the potential is that, and I don't want to get into this because it's going to be next month, is making that change to expand the retail court.
well. Mhm.
Or not.
Or
not.
Right. Another option, as Sonia said, is we can make brew pubs in mixed use a special use. Or recommend that,
Right.
Right,
So
again, if
that
we
would not
want,
preclude a brew
if we
pub.
want to make it a special use, I'm fine with that, instead of just permitted.
In both locations? In both the core as well?
Well, it is in the core, that's
Right.
that's where it is in
It's
the
permitted in
core.
the retail court.
But I understand what
Right, but we're talking about the
we're saying is
definition
that
of
the
what's
distillery
permitted.
is already a permitted use. So,
With no food service, so.
right.
Is
The real
commission-
dilemma is where the potential of the new one's gonna go is really towards the peripheral, but potentially gonna be changed, potentially,
That's next month.
right? So we're in this kind of quandary in between two of how we're viewing this, or at least I am, I should say.
I would advocate that for consistency, we make it a permitted use, except in the mixed-use periphery.
Would you be willing to add them as special uses in the mixed-use periphery? Or keep them out completely?
I would say it would be a special use.
I agree, we've already heard from the public saying that, suggesting that.
So your recommendation would be for brew pub and craft distillery to make them special uses in the mixed-use periphery?
Yeah. It's a burgeoning field.
Mr. Mendoza?
I get the initial logic in lumping them together, but are they really the same thing? The brew pub and the craft distillery?
Well, they are serving on-site the beers, or, you know, the
They-
product that they're making.
they
They're not
are-
providing any food.
They are, but the reality is that people are more likely to consume heavily at a brew pub than they are at a craft distillery. Beyond the initial similarities, I don't know that they really are the same thing and pose the same potential problems for the residents. So I'm not sure that they necessarily need to be treated exactly the same. They may end up with the same classifications, I'm just not comfortable lumping them together all the time for all discussion. If it's a special use in the mix, that's fine. With me, I just don't want to lump them together.
Okay. So general consensus to make brew pubs a special use per the new definition in the mixed-use periphery, keep them as permitted in the retail core, and add a craft distillery as a special use in the mixed-use periphery? Or do we not want to touch craft distillery at this point?
I don't think we touch it, I mean, at this point, no.
I agree.
Just leave craft distillery as it is?
Yes.
Yes.
For now, okay. All right, so we'll add brew pub as a special use in the B2 mixed-use periphery. And then the definition that we have before you removes the requirement that it be a full-service restaurant. This states that it's a commercial facility that includes the on-site manufacture, storage, and retail sale of beer for consumption on or off the designated premises.
Does this definition track exactly the state definition?
Pretty similarly. That's why we added the a brew pub may also offer for sale at retail.
Is that part of the state?
That's part of the state's wording in their application
Right.
for the brew pub specialty retailer license.
I thought the concern, though, from the public was that a brew pub not serving food would be less desirable than one serving food, correct? Am I correct?
Yeah, that's what I wanted.
So that goes back to the definition, so the question is, are we changing that definition to eliminate food and then adding the special use as well? So being more permissive when they're asking for more restraint.
And what you've just done is made it not necessary to rezone that periphery property that they want to use as a brew pub by saying that it's a special use.
I'm just trying to keep things straight from our discussion here. So our discussion originally started with the definition of a brew pub, whether we're going to change that to allow them not to serve food, to granting the rights and special use and mixed use, which hasn't been part of the discussion yet, so.
Well, it was, that's why I asked, what was the Murphy's specific concern? Was it the change in the definition or the status of permitted use versus special use? The impression that I took from it was that it was more the use category as opposed to the definition.
No, I took it from the definition part of it.
It's partially the definition, but it's also that we don't think brew pubs are appropriate in the mixed periphery zone.
Yeah, that's, I took from that it was more of a classification issue than a definition issue.
I thought there were both things going.
And am I right in understanding that the proposal is to make the brew pubs a special use in the periphery zone?
That is in response to your discussion and your husband's.
But that's
Which
pretty much
means-
the opposite of what we've advocated.
Well, special use means you have to do a public hearing, you understand that, right?
Right.
Okay.
So I guess,
So the prevailing thought is we don't want to not allow them. And I think that's what your husband said as well. We don't want to categorically not allow them.
Right, in the retail
In the retail
core,
core.
not in the periphery.
The periphery up against the resident, if I didn't make that clear, I'm sorry, the periphery zone, the stuff doesn't have any business there.
If the- if the-
I don't want to say downtown you can't have a bar. just think you should look closely before you have a bar downtown.
Okay. I didn't take that from the discussion.
Yeah, I didn't either. I understood it the other way around, that you were saying that there, you could understand certain situations where in the periphery you might have a brew pub.
But I understood it from the standpoint of not serving food in the mixed periphery, right? If there's not food being served in the mixed periphery, then it seems more objectionable.
There's really
Correct.
two issues here. One of them is the definition of brew pub, and whether or not at any place in the village is comfortable having a brew pub that doesn't serve food. That's kind of one definition, discussion. And another discussion is whether any brew pub under any definition will be a special and permitted use in the periphery zone.
So in the periphery zone, is the objection that they're manufacturing their own, or
No,
producing their own beer?
it's-
Because how is it different from a restaurant that would be serving beer and alcohol then, if they were serving
I
food?
realized until I got over here today that you could put a restaurant in that zone. That was.
Right, so
And
that's my
I
question.
define it as a special use, actually, under what you discussed as a restaurant would be a special use in the periphery.
So if they're serving food, then you would be less objection.
Yeah, Greg, I think the objection is that you talk in our understanding of the mixed use, which apparently was incorrect, was that it was essentially residential or 9 to 5 type work, and you were, and that's fine. That's the transition, right? It could be either residential, it could be a basic businesses. I think the point where we object is that if you're gonna run late in the evening on weekends in a residential area, that's, and I didn't realize until it's brought up this evening that that was already an approved use in there.
Okay.
So just for everyone's benefit, it's okay to sort of clarify with them what they were saying, but let's, after that,
Sure.
keep the discussion.
Right. That's what, I was just trying to keep that.
I understand.
So, Sonia, do you want once again to clarify what we are agreeing to?
All right, so let's look at
Restate.
brew pub again.
Can I ask one
Definitions.
question
Yes.
before you do that? Is just the craft distillery
Yes,
is currently not allowed in the mixed use periphery?
that is correct.
Okay.
So we have two issues with brew pubs to discuss at this point. One is the change in the definition to remove the requirement of it being a full-service restaurant that also serves alcoholic beverages that are manufactured on site. Two, just a commercial facility that includes the on-site manufacture, storage, and retail sale of beer for consumption on or off the designated premises, ... that talks about number of gallons of beer sold per year. And then it says, a brew pub may also offer for sale at retail for use and consumption on a licensed premises any beer or wine purchased from a licensed distributor or importing distributor. We couple that with the fact that that is considered a permitted use in the retail core and is not permitted in the mixed use periphery or in the public use zone. They are permitted in both the B1C and the B1TC districts. So it was brought up possibly making it a special use in the retail core. Do we want to continue along that avenue, or do we want to leave it as is, where they're only permitted in the retail core and not permitted in the mixed use periphery?
Shall we agree on the definition first?
We can start there.
Yeah, I took from the earlier discussion that there was, that we were comfortable with coming up with a second definition, brew pub with food and brew pub without. And
Well, I thought that would be more listing it under uses. So we could list it under uses, brew pub with full-service restaurant, brew pub without full-service restaurant.
Well,
Brew pub says it can have either, but then we break it out if we wanted to go that way.
What's the difference between a brew pub that has a full-service restaurant and a restaurant that serves alcohol?
They're actually
I
producing.
mean, other than brewing,
It's the brewing portion of it on, the manufacturing on site that I guess is the.
Right, that's the only difference. So the threat of the people coming and drinking and being late is really the same potential concern that you would have with a restaurant that has a liquor license. For all intents and purposes, there's no difference, other than the manufacturer, which I'm not sure anyone has a concern about the manufacturer.
So under the proposed definition, a brew pub could serve food.
Yes.
They're not
And-
prohibited from doing it.
Right, and probably some would. It's a revenue stream.
And if they want to be in the mixed use periphery, they're going to say, I know I'm really a restaurant that manufactures.
Well, we wouldn't, I mean, the manufacturing of beer immediately clicks it into being a brew pub.
So then we come back, what's the difference between that? Other than the manufacturer, it's a restaurant that serves alcohol.
Which we already
Which we already have said is a special use.
Right, in the periphery district.
And we're wedded to that?
Pardon me?
We're wedded to that? Making restaurants special use and mixed use?
Not
It
necessarily.
already is.
Right.
Restaurant?
Restaurants are,
Drive-through is
already
currently a
in there.
special use in the mixed use
But the
periphery.
other
it was
one is not.
actually a permitted
Permitted
use, and we
Right.
changed it to
I
special.
know, I'm wondering if we're wedded to that.
Yeah, I don't have a problem with that. I guess I don't have a problem with brew pubs being a special use in the mixed peripheral either. As a special use and permitted in the, what is considered the retail core.
I'm of the same opinion, actually.
What?
I'm of the same opinion that
Yeah,
you just
I agree.
stated, but
It's consistent.
It's consistent then.
So, what's consistent? I would say for consistency, a brew pub with, that serves food could be a special use in the periphery and mixed use, to be consistent with our restaurant.
So you're
And
looking
then
to,
a
you're
brew
looking
pub
to break
without,
them out. You're,
yes.
you're looking to break out two separate lines. One is a brew pub, one is a brew pub with food. The brew pub, it could be permitted in both, the brew pub with food and the brew pub could be permitted in the retail or the, our retail core. And then the brew pub with food could be a special use in the peripheral.
Or can't one establishment be a brew pub or not, and a restaurant or not, and they pick the combinations that they want?
No, because
Why
the
do we
issue
have
at
to put them
hand,
together?
the issue at hand is the manufacturing. What makes.
Yes, I understand, but if you're a brew pub, I don't know why I'm having trouble saying that, you're either also a restaurant, or you're not a restaurant.
Yes.
I mean, there are two separate categories and two separate lines, so one firm is going in on two lines of the table.
I
We
understand
have
what
to
you're
be
saying.
careful
You're-
if
you're-
we get into, I mean, I suppose now that we're taking out restaurant from there, maybe we don't have to be as careful. You do have to be careful with the manufacturing of beer, and then you get into the classes of, are we getting into a craft brewer? And that's a larger operation. You know, so,
Are you saying we have to have that in here too?
no, I'm just saying, if you're gonna say that a brew pub is a restaurant,
No,
For the restaurant.
no, I'm saying a brew pub is one decision. You've got the brewery, and they can also buy from a distributor other beers, and they're selling brews. They also can be a restaurant or not a restaurant. If they are not a restaurant, then
then they are just a brew pub.
they're just a brew pub. They can be a brew pub and a restaurant. And so then they have to qualify under the two categories, which is why I think we were arguing it's a, what what do you call it, S, what's the S called?
Special use?
Special use. You have a special use for both of them in the transitional and the peripheral category. That's
So
consistent.
they would have to get two special uses in order to
Well, I'm
be
sure
a
we can
group
figure
home
out,
with restaurant facility.
I'm sure we can figure out a way to make it one application for the two. We don't have to have them applying for
I mean,
two.
don't you assume that the manufacturer of the beer becomes the primary criterion that you look at?
I mean, that's gonna be probably the primary income.
Right. So, David, can you just restate, because I think you most clearly articulated, I think, where we are converging. So can you just restate that? And then let's have an up or down on what David.
Well, I mean, there's potentially two things here, okay? Have two lines, one that's a brew pub with food, one that's a brew pub, okay? If it's a brew pub, it can be permitted in the retail core. If it's a brew pub with food, it can be permitted in the retail core. If it's a brew pub, period, in the peripheral district, that's something that we have to decide if we want to allow. If it's a brew pub with food, it can be a special use in the peripheral district. That would be, so the only unknown factor there is, and if you say yes, it could be permitted as a special use, then at a certain point it doesn't matter. They're both brew pubs. They're both being permitted and they're both being allowed there. So the question is, do you want to allow just a manufacturing of craft beer to be at all put into the peripheral districts? That's the question.
An establishment that serves alcohol without food, that's really, I think, the
tasting
question.
Yeah.
Pardon?
A tasting room.
But
And that's what most of
unfortunately,
the-
and I like the way that Mr. Mendoza said, is that you do have different clientele. I mean, someone's gonna have potentially easily 5 or 6 beers without even thinking about it, whereas someone probably going into a craft distillery is probably not gonna do that. Have 5 or 6 mixed drinks. Not to say that it doesn't happen, but I think the different types of clientele and the potential of people going in there could be a real difference. The question is that I think we're really looking at, is a brew pub going to be allowed in no matter how you define it in the mixed peripheral? And to me, if it's a special use, then it's something that allows us to talk about.
So I'm comfortable with making that application a special use.
I don't think we need to worry at this point, brew pubs with food, because as I'm going through thinking of brew pubs that are opening up now, most of them don't have served food. If people have other opinions, please share, but for now, we can keep it simple.
So then, if we go that approach, then what that says is, with respect to the definition, we go with the proposal to strike the language full-service restaurant that also serves alcoholic beverages, to keep the definition in line with state statute. And then with respect to the usage, we're saying that it's a permitted use in the brew pub as defined, would be permitted in the retail core and special use in the peripherals. Is that where we've ended up? Okay, so that would be our recommendation with respect to brew pubs. Okay, may I then have a motion to, so you're looking for us to, what would actually the motion be, is to approve the proposed language with the changes that we have discussed.
The changes that you've made, the
Exactly.
recommendation to
Okay.
add a separate definition for art studio.
Correct. So do I have a motion accordingly?
So moved.
Second?
Second.
Any discussion?
Celine, would you please call the roll?
Okay. Commissioner Gary?
Aye.
Commissioner Lesniak?
Yes.
Commissioner Mateo?
Aye.
Commissioner Mendoza?
Aye.
Commissioner Pelletier?
Aye.
Commissioner Randall?
Aye.
Chairman Kuchar?
Aye.
Recommendation passes.
Okay.
May I request a very brief?
Yeah. Thank you, gentlemen, for coming. Okay. We've had a request from the commissioner that we take a short adjournment. So if we can be back here in
2 minutes.
3 minutes, 8:35, we'll resume.
And
All right, if I can reconvene our proceeding this evening. Okay. Thank you. Okay, so what we are going to do is we believe that the discussion, the public hearing with respect to permitted encroachments for double frontage lots is, we don't have anyone here who's particularly interested in that, so we are going to, for the benefit of those who are here with us this evening, we're going to move to agenda item 8A, which is a discussion of the site plan. We're talking about making an amendment to the site plan of the Village Center property. And what I'd like to do at this point is invite Sonia to make staff comments on that proposal.
All right. President Zell just kind enough to call and say that I cannot be heard on tape. So he asked me to come to a microphone to speak so that I can be heard. Also asked that your microphones are not picking you up. So if you can please make sure you lean forward and speak into your microphone so the folks at home can actually hear what we're having a discussion about. So thank you. They're on.
Okay. Check.
All right, you have before you a site plan amendment for 2 to 10 East Burlington Street, which is the Village Center. They're proposing a site plan amendment in order to accommodate additional kitchen and seating space inside for a proposed restaurant. They're looking to create a walk-in cooler that would be placed outside of the unit. This would remove 2 parking spaces on the exterior of the building in order to accommodate that walk-in cooler. The zoning ordinance states that any reduction in parking spaces constitutes a major site plan amendment and therefore requires the Planning and Zoning Commission review as opposed to an administrative review for that amendment. There are currently 16 at-grade parking spaces deeded at the property. They're proposing to remove 2 of those that are on the north side of the building adjacent to the loading area. These spaces are located under the 2nd and 3rd story condominiums, and this would leave 14 parking spaces at grade on the property. The proposed cooler is 18 feet by 16 feet, and it would be accessed by the building only. The coolers would be screened by some louver screening wall, and it would be approximately 17 feet from that north property line, which is zoned R1A. The proposed walk-in cooler may impact visibility for cars parked on the adjacent parking spaces from the westbound cars in the drive aisle. Therefore, staff would recommend the addition of either a stop sign or a yield sign for cars heading westbound on that drive aisle. This would allow the parked cars to more safely back out of those parking spaces since their vision would be obstructed by the cooler. So should the Planning and Zoning Commission recommend approval of the site plan amendment, the following conditions should be applied. A stop sign or yield sign to be placed across from the cooler for westbound traffic. A copy of the site plan amendment approval shall be signed by the chairperson and the petitioner and kept on file in the Community Development Department. A building permit must be obtained by the petitioner, and the building permit plans must match the approved site plan amendment dated 2/15/16. The petitioner's representative is here to answer any questions that you have. I also can answer any questions that you have regarding the proposal.
I'll ask just the one question that probably I probably already know the answer to, but the compressors and the condensers for the units are going to be on top of the units?
I believe there's been some debate on whether they were going to place them as a rooftop unit or on top of the...
Rooftop, where would they go? Rooftop, or
Of the building?
Mm-hmm. Where the condensers for the coolers can be placed, they can place them
compressors,
or as a rooftop unit.
They would either be on the condensers would either be
on the top of the cooler, or they'd be on the side of the cooler behind the louvered screen.
That didn't leave you much.
There
That's the reason why I asked. It
hasn't
didn't leave you-
actually been determined yet, but it'd likely be at one of those two locations. Those would be the primary suggested locations. The secondary spot would be to have to run the refrigerant lines to the roof of the main building and put them on the top.
How high are these typical coolers? How tall? 8 feet, 9 feet?
From the ground to the underside of the building, it's
Well, the underside of the building is
about
like
15
14,
feet.
15 feet, so the coolers are only gonna be
The
9
coolers are
feet. They
eight-
put
eight-
the
9
only
feet.
reason I'm asking is if they're on top of the units, that's fine. I was just wondering if they're gonna be on the sides or whatever, what space are you taking up? So if they're on top, I don't have a problem.
Yeah, depending on the final design of the cooler, they'd either be on the top or on the side or remote. They can be done any one of those ways.
I guess my concern with respect to that would be the noise. Is there a concern about noise if they're physically on the cooler, whether they're on the top or on the side, as opposed to being up on the roof? If they're on the roof, you
I
won't
don't
hear
know
them.
if you can get them up on those roofs.
That's 4 stories.
Well, a lot of those are outside patios. I'm okay with them on the top. I just don't want to see another parking space, I guess, removed because I gotta
Right.
put down my condensers, I guess. That would be the only question.
The village does have noise restrictions for mechanical equipment, so they would be held to whatever the required decibel levels are for mechanical equipment, which I believe is about 55 decibels at the property line.
Okay. Any additional discussion, questions?
Yeah, I guess the previous planning commission and the village went through a lot of negotiations when this building was being considered. I wasn't part of that, I don't know the details on it, but I know I saw a lot of stuff in the newspaper about how difficult it was. And we see in the paperwork here that as I read this, maybe I'm not reading it properly, but that parking space number 39 shall be removed, and then the second item is that there's going to be an $85,000 fee in lieu of providing the full 17 parking spaces, and instead there are 16 because 39 was removed. All those negotiations took a lot of time and a lot of energy on the part of people, and I can't see how we as a planning commission should be changing the number of parking spaces now without the knowledge of what happened previously. If you were coming to us and saying, okay, here are the calculations that were there before, here are the things that have changed, and because of that, we can therefore reduce it to such and such. But instead, you're coming to us with a restaurant for 232 seats or 230 seats of some kind or other, and we're removing, for no reason at all other than convenience, we're removing 2 parking positions. I'm kind of, why is this happening?
Well, the requirement is a little bit different now than it was at the time. When the site plan was originally approved, the required parking for the site was 59 spaces. They provided spaces in the underground parking as well as the at-grade spaces, and they had the approved site plan that indicated those spaces, and they paid $85,000 in lieu of providing 17 additional spaces to meet that requirement. So they basically paid to have the required parking reduced by 17 parking spaces, and that's built into our code. They've built the building, they have the parking underground, they also have the parking at grade. They provided more parking at grade than was in the approved site plan. Additionally, what they built, they changed their unit dynamic for the condo buildings, And so they reduced the number of 3+ bedroom units in that building. So that actually lowered the required parking by 3 parking spaces. So at this point, we're not actually losing any required parking, but we are losing parking that is on the current site plan. Therefore, we're going through this site plan amendment. So we're not actually losing any required parking, but we are losing parking spaces, which does trigger the need for a site plan amendment.
See, before I agree to anything, I'd like to see those calculations laid out. I mean, the way this reads with the material that we received, it just sort of says, give them 2 more spots, and we've already negotiated, and they've already paid for reducing their list before. So I've kind of missed the boat on this whole thing. The other thing is, as I said, I guess it's 216 seats in the restaurant that are going in there. The other possibility, though, is that I've been in the Edward Jones offices there, and it seems to me that they've got space in the back of that office which aren't used very heavily. Instead of losing parking spaces when we're adding 212 or whatever the number is seats in a restaurant, that we keep those extra parking spaces, and that you try to negotiate or talk to Edward Jones at least. There are 2 Edward Jones offices there, about the possibility of using some of their area in the back of of those offices.
Well, I don't think the issue really is about losing. It is about, they're taking the parking spaces, but it's mainly to have them be able to put their coolers and their freezers outside the restaurant instead of inside the restaurant. Again, I look at this, and I was on that whole planning commission for this, the village center that has now sat nearly vacant since it was built. And I've also been to a fair amount of the restaurants in town and been the only one parking in the village lot that's associated down there. I think for the sake of actually getting another business in this town and giving people an opportunity, it's a very small price to pay for what we can get out of it. Instead of leaving a space vacant, I'd rather say, okay, if we have enough parking, which we do, we have on-street parking also over there. I think if parking becomes a problem in this town, it's going to be a good thing.
Hey, Commissioner Gary, if I could address your concerns. I had concerns when looking at the history of this too, and I wanted to learn more about the history. And after I sat down with staff and we went through the historical documents, I concluded, as staff did, that they are, as built, they ended up in excess of the number of required spots that they needed once we figure in the parking in lieu. And with losing these 2 spots, they are not going to fall below the required amount of parking. So the only relief that they need is this site plan amendment. And I do understand from staff that there is some time sensitivity to this. And I guess I would tell you, I was satisfied after learning, after staff walked me through everything, and I'm sure Sonia would be happy to walk you through in detail all the calculations and stuff. But if that might be acceptable to you, as opposed to continuing this matter for that further information.
So what you're saying is that with the removal of these 2 parking spaces, they will still be compliant with the parking requirements?
Absolutely.
Exactly.
Yes.
Because of other changes that have occurred since the original approval?
Yes.
Okay, and that wasn't stated in here, or at least if it was, I missed it. Okay.
Any further discussion or questions? Then may I have a motion?
I'd like to make a motion that we accept the revised site plan to remove the 2 spaces on the north side of the building for their freezers and coolers.
Second.
Sonia, do you need more clarification in that motion with respect to
Is it
the
with
staff
the conditions
recommendation?
that staff recommended?
Absolutely.
With the conditions that the staff are.
Thank
Okay.
you.
Okay. All right, so we have a motion, it's been seconded. Sonia, would you kindly take the roll?
Certainly. Commissioner Lesniak?
Yes.
Commissioner Mateo?
Aye.
Commissioner Mendoza?
Aye.
Commissioner Pelletier?
Aye.
Commissioner Randall?
Aye.
Commissioner Gary?
Aye.
Chairman Kuchera?
Aye.
Motion passes.
Thank you.
Thank you, Don.
Okay. All right then, if we could then kindly move to agenda item 8B, business sign reviews. We have 2 of them this evening. The first one is with respect to the property at 33 East Quincy Street. Sonia, would you kindly
Certainly.
help us understand the situation?
Yes, the first one is for 33 East Quincy, which contains Higgins Glass and Gaslight Realty. It's Zone B2 Retail Core, and they are proposing to put in 2 blade signs that are non-illuminated. Based on the rendering, the blade signs will not extend above the cornice line or the second floor window line. The clearance will be 8 feet, which is required by code, and the clearance from the facade is 3 inches, which meets our maximum of 6 inches. The size is a 24-inch diameter round sign. Its projection is going to be just over 30 inches. Our maximum allowed is 42 inches. There's not going to be any illumination. The sign is going to be approximately a 1/4 inch thick cord aluminum. The bracket is black flat bar steel with bracket rings to hang the sign from. The locations are going to be, if you want to look at the rendering, there's the main door there for 33. The locations are going to be on either side of the windows that flank that entrance door. You have a rendering of how it would look from the building.
Now, are these painted aluminum signs? Would you know? They are painted?
It's an applique. It's a little vinyl applique. It's a custom color graphic.
Okay, so it's applied?
It's applied.
It's applied to it?
It's specifically for exterior use. It's not for shop.
So the Planning and Zoning Commission, when we adopted our sign code changes, had asked that the first applications for blade signs be brought before the commission for consideration. So that's why you have them before you to review. They do meet the criteria of a sign. They are harmonious with the building and the surrounding area. The design is simple and will not detract from the architectural detail of the building. The proposal is a plan for both units of the building, and they're going to be, they're a kind of match, they're similar size, or they're the exact same size, they're the same bracket, so everything's cohesive. They're not brightly colored. One is the black background with white lettering, the other is dark green with yellow lettering, and there is no illumination, so we don't have any issues with that.
And you have the wall brackets as steel, are they painted steel?
It's a standard, it's a off-the-shelf bracket. It's a painted black steel,
So staff does recommend approval of the proposed signs for 33 East Quincy.
I have a point of order.
Yes?
Sorry. Because I'm in 39 East Quincy, which is under the same ownership and the same designs, do I need to recuse myself from this discussion, or?
You don't have any legal obligation under that circumstance because you don't have any contractual interest in this matter. You're not financially benefiting from this matter. But if you feel more comfortable, you're free to, if you feel you can't
I'm just
make a fair
curious, because
decision.
it's the same owner, same set of design criteria.
Did you design the signs?
I designed ours, so
And that's
within
the next
the framework that has been established by Mr. Pipel. So
If
But
you
that's
feel
the
you
next
can make a
step.
fair decision on this, you're welcome.
I think
to
they
make
look
a
great. But
Okay, any further discussion or questions of Sonia?
I presume both this and the next one will be contingent upon all changes we're going to do in the next order of business.
Well, only
This
the
one
first
isn't.
one. Only the second one would be,
This one has nothing to do with the sign.
Yeah, this one meets all of the requirements and does not, is not contingent on any change to the ordinance. So if we want to take this one first and just vote on that, and then we can discuss 39 East Quincy.
So may I have a motion with respect to specifically the sign permit application for 33 East Quincy?
I'll make a motion that we approve 33 East Quincy sign permit application.
Do I have a second? Okay. Sonia, would you kindly take the roll?
Sorry. Commissioner Lesniak?
Yes.
Commissioner Mateo?
Yes.
Commissioner Mendoza?
Yes.
Commissioner Pelletier?
Yes.
Commissioner Randall?
Yes.
Commissioner Gary?
Aye.
Chairman Kuchera?
Approved, yes. Yes.
Next,
Motion passes.
motion passes, sorry.
Okay.
Next, we have the application for 39 East Quincy, and I believe Commissioner Randall has to recuse himself from this portion of the discussion. Our applicant again is Mr. Pipel. The businesses in this unit include Blueprint Tours, Skills Tutoring, Quincy Street Distillery, and Randall Architects. It is Zone B2 Retail Core, and the proposal is for 4 non-illuminated blade signs on the building. Based on the submitted rendering, the blade signs will not extend above the cornice line or the second floor window line. The clearance is 8 feet, which is required, the minimum required by code. The clearance from the facade, again, is the 3 inches, which meets our maximum of 6 inches. The proposed spacing, however, we have the owner is proposing 2 signs on either side of the main doorway, which has a 13-foot separation. He would like to place the other 2 on either side of the overhead door, which are also approximately 13 feet apart. A proposed blade sign at the end of the building does not meet the requirement that blade signs for second floor tenants be within 6 feet of the door servicing the business. The owner has a proposal that meets the requirement and places 3 signs, the one for Blueprint Tours, Skills Tutoring, and Randall Architects, around the main door that meet the 6-foot separation requirement that we have. However, the owner feels that this will look crowded and will not meet the intent of the code, which is to prevent crowding of signs along the facade. The owner is requesting that the village consider removing the restriction for second-story business blade signs. This code amendment is also on tonight's agenda for consideration. The sizes for these signs are the same size as the signs for 33 East Quincy. They're 24 inches in diameter, and so are 3.14 square feet. Our maximum allowed is 6 square feet. The projection is just over 30 inches, and they will be a 1/4 inch thick poured aluminum. They have a black metal bracket with bracket rings to hang the sign from. There is no illumination proposed. You have a little diagram here in your packet that shows their preferred locations, which shows the sign, the Blueprint Tour sign and the Skills Tutoring sign on either side of the door. And then you have the distillery sign on the west side of the overhead door and the architect's sign right near the end corner of the building, which would be on the other side of the overhead door. That's their preferred sign locations. To meet the code, they would put the Blueprint sign at the edge of the building, Skills right next to the door, and then the architects on the other side of the door. And then the distillery sign would remain in the same location. So instead you would have 3 signs 6 feet apart right around the door in meeting the code requirement. So the signs themselves all meet the code. What doesn't meet the code is the one sign's location. They can make it meet the code, however, their preference would be for it to be located at the end of the building on the other side of the Quincy Street Distillery sign. So we will have a discussion on the possible code amendment that would allow that to happen, but we can make a recommendation on the signs as proposed, or we can discuss the sign amendment and then go back to this, depending on which direction you're willing to consider.
Does that mean if we go back to 7C, is it 7C? Or is that opening up the public hearing, or is it opening?
There's no public hearing
Okay,
for
for the
this.
sign, so then I don't know, I would suggest that we talk about the changes to the sign code, because I would have to agree again with the petitioner to say that obviously aesthetics would be a lot nicer to the way that they drew it than putting these three signs that close together, because the one in the middle actually will get blocked by the other two. It would be very difficult to see it. So I don't know if it's up to the other commission if you want to.
I agree completely with that. I'd say let's just go ahead and pass this with the exception, if we change the code afterwards, we're okay, it matches, otherwise it,
I don't know if we could do that.
No, you can't. Procedurally, I think we need, first let's address the proposed change to the code,
And then
and
we
then
can
come back to this.
because if we change the code, this becomes somewhat automatic then.
Right.
Mr.
I mean,
Chairman?
Well, we
what's-
can recommend approval of
what's
this
the-
subject to the code being approved.
Okay.
And then once the board adopts the code change, then I will be able to issue the permit.
And if we don't agree to a code change, then what?
we gotta come back to this.
Well,
Well, no,
then we can vote on his proposal that does meet the code requirement.
I won't do that one. Second, terrible.
So there you go. So I'm sure he'll weigh in on our code amendment discussion as well.
So I guess the question becomes, are we permitted to approve the proposal that doesn't comply with the ordinance?
Well, if we base it on the approval of the changes to the,
We'd have to change the ordinance, but if we don't change the ordinance, how can we, if we are comfortable with the ordinance as it is,
then,
but in this particular case, we don't like how it's applied, do we have an option of approving it without changing the ordinance?
Variance.
But why don't we pause our discussion of B and go on to C? And-
Okay.
and
Please.
Now that we have some context for that discussion, we can make a decision.
Before we do, one other nitpick, why is it we're charging an electrical permit on these?
We're not.
Oh, okay, so both of them should be 0 instead of 75.
There is on there two
There's a
fees, sign permit fee, electrical permit fee. I only charged him the sign permit fee
Okay, so the other one
since he's
should-
not doing any electric.
Okay, so both of those should be 0.
So before we transition to 8C, I just want to give Commissioner Pelletier, I keep doing this. Jill, would you please like to, I thought I heard you say,
Yes, please.
Yes,
Let's
please.
talk about C, please.
oh, okay, great. Thank you, Commissioner Mateo.
No, it's stay out of this as well.
Yes, Scott.
That's all I needed to know.
So Sonia, would you please introduce topic 8?
Okay, so we have a sign code amendment related to blade signs before you. The Planning and Zoning Commission spent many months reviewing sign regulations for the B2 zoning district, and they were adopted in April of 2015. Part of the revisions included blade signs as permitted additional signage in the downtown. This was a recommendation of the CMAP plan as something, and also something advocated for by the owners of 33 to 39 East Quincy. The sign code allows second-story businesses to have a blade sign. However, it requires that they must be placed within 6 feet of the doorway serving the business. This mimics the language for directory signs for second-story businesses. The Planning and Zoning Commission asked that staff bring the first applications for blade signs before you for approval before issuing the permits. The village, as you have heard, has received its first application for blade signs. The owner, however, is having some difficulty with the placement of the signs due to the restrictions on where a second-story business can place their signs. The building has 3 second-story tenants and only 1 entry door.
Correction, there's 2.
2? Okay. I apologize. So he has 2 second-story tenants. And then 1 first-story tenant that's also right by the door. So this would place 3 signs around the front door and would make it appear very crowded. In looking at other buildings, such as the arcade building, staff is concerned that the restriction on proximity to the entrance for second-story tenants could cause some issues with blade signs on that building as well. Since this is our first application for a blade sign, and there are already issues, staff believes it would be prudent for the Planning and Zoning Commission to reconsider its recommendation on the restriction for second floor businesses. The commission has the following options. Option 1, no change. The existing language is, G, such signs shall only be located on the frontage of establishment that the sign identifies, except for second floor businesses which may install a blade sign within 6 feet of the doorway serving said businesses. Or, option 2, recommend to the village board a sign code amendment that would continue to allow second-story businesses to have a blade sign, however removes the proximity limitation on where they can be located. That revision would read, such signs shall only be located on the frontage of the establishment that the sign identifies, except for second-floor businesses which may install a blade sign on the first floor, provided it is located no closer than 6 feet to any other blade sign on the same building, and the location has been approved by the building owner. The sign code is part of the building code and does not require a public hearing. If the commission recommends changing the regulation regarding blade sign location, the recommendation and ordinance amending the village code will be forwarded to the village board for approval. So that is where we're at with blade signs. Any objections to removing the restriction?
No,
I have no problem removing it.
What
Based
date?
on what I'm seeing here, yes, it makes sense to remove the restriction.
it defeats the purpose to have them crowded. Nobody would be able to see the signs from the 2 directions, and it looks bad. But for our other signs, we don't say it has to be approved by the building owner, so isn't that built in that the landlord is the one putting up signs? I'm wondering why we're having it for blade signs, but not for our other sign types.
I suppose I'm looking for an explicit approval by the property owner that they're okay with the blade sign being located somewhere that's not right in front of an actual unit.
Sounds good? Common sense?
Because this and the directory signs are really the only 2 places where we allow a second-story business to have a sign not on their exact storefront.
It seems like all of the blade signs that are, the pictures and everything, and all the discussions and what we're showing here, they all go back to the medieval concept of hanging your shingle. They're all hanging in some way, shape, or another. It does say a rigid attachment, so that implies a rod coming out in some way. But are we explicitly outlawing somebody putting, not that I would argue for it, but I just, conceptually, are we specifically not allowing somebody to go up there with some sort of a bracket that's mounted there and a street sign that comes straight out as a blade that otherwise matches everything? And the reason I asked that is because you asked us whether or not that was 6 inches more than or less than. And this, I agreed to it being, in here it still says no less than 6 inches between.
Correct.
And so
That was an error on my part in writing it. Your recommendation, as I recalled and my notes said, was that it was a 6-inch maximum. However, when it was written, it went before the board. I did not catch that I wrote it as a minimum. So that was an error on my part, and that's how it got recorded, but that was not your recommendation as the Planning and Zoning Commission. As my notes had it, and as I was asking for those of you who are on the commission now that were on the commission back then when it was being discussed. So I got some confirmation from some of you that it was supposed to be a maximum.
Okay, but that goes back to the idea that when I said that, yes, I agree, it should be a maximum. I think in my email I said something about it could be, I didn't explicitly say it, but the implication was it could be 0 if it is attached to the wall and coming straight out. There's a metal bracket on the wall, and then it's inserted into and attached to that bracket. Are we allowing that or not? If we are not allowing that, then a hanging sign, I'm changing my opinion. I would say that it should be a minimum of 6 inches to ensure that there's enough separation between the sign and the wall. Because in Charlie's case, and the cases we're talking about here, there are columns that protrude out some 4 inches, and yet the sign is only going to have a 3-inch clearance from the facade. So technically, it's behind the front of the bricks, not that it's going to hide things, but the signs are going to be more lost in the architecture rather than hanging out there clean and free to see.
Yeah, that's an astute observation. I was also sort of hamstrung by the 8-foot clearance. So the architecture really doesn't allow a sign, higher than 8 feet because I would have the room for it. So literally, this was the bracket, like looking at hundreds of brackets. This is the bracket that allows me, and that's sort of what determines the size of the diameter of the sign too. So it's literally the bracket and the size of the sign allowed me to get the 8 feet clearance that I needed by the code.
And that brings you into the 3-inch
And that
clearance.
brings me into, yeah. So yeah, that was one too, I didn't really understand, the 6 inches, whether it was a maximum, minimum. I don't think it really matters, candidly, as an architect, whether it's a maximum or minimum, because then you're sort of going, if you look at brackets, like they have both. The important thing is the distance of the extent of the sign to the building. Like, how much does it jet out into the public right away and try to grab your attention?
Charles, you want to come up to the mic?
Yeah, I'm sorry. So that for me, that really wasn't a huge consideration, that 6 inches, because I didn't quite understand if it was a minimum or a maximum either.
I guess what I'm eventually getting to is just the whole idea. I just like the old-fashioned, as they say, medieval concept. Go out, hang your shingle on the hooks, and it's swinging in the breeze. And when you leave, you pick it off, you leave the ladder there. The next guy comes in, he hangs his sign.
That's
And
sort of the
everything is
intent of
side
the
and
design,
hanging.
right?
And it's got a quaintness, sort of, I think, the kind of concept that we want in Riverside, as opposed to a street sign, which is just a piece of metal sticking out. It's permanently attached to the building, which I would not like to see, but yet I think is still allowed under the blade sign definitions, because it only says a metal attachment to the wall, and that the sign has to go into it, which doesn't rule out a street sign. So
Well, as I recall from our conversation, when we were going over blade signs, is we did not want to be overly restrictive on the creative designs of whatever tenants were going in there and how they wanted to express themselves in their signage. So although some commissioners may tend towards a more old-fashioned sign, they were not necessarily wanting to preclude somebody from putting a more modern type of sign on there. What we were clear about is we did not want the plastic signs. We did not want them to be internally illuminated. However, we wanted to give people some artistic discretion with the type of signage that they did. So we kind of pulled back a little bit from how restrictive we wanted to be with the blade signs and tried to stick a little bit more to placement and how far they would be allowed to project, and being a little bit generous with the size to allow people to be able to go to a 6-foot square foot sign, to be able to do a 3-foot deep sign, and then give them that extra 6 inches at the most to have that clearance from the building and still be able to have a 3-foot long sign if they wanted to. So that's kind of where I recall the discussion playing out, because there was some discussion. Do we want to pick and say you can only use these types of brackets? And the commission, decided that they did not want to go in that direction. And we tried to keep it a little bit more basic. So yes, somebody probably could do something like that. Hopefully staff and the Planning and Zoning Commission could help them make a tasteful display of that type of bracket and mounting decision. So I don't necessarily know that that would look awful. I think we could accommodate that for a more modern sign for a company that perhaps is a little bit more modern.
Okay. Then I'm happy with the way it stands and with the answer I gave you on my email. The other question I wanted to raise is, it seems to me that there's an issue under G and H, I think it is. Yes, such signs shall only be located in the frontage, and then the other one is such signs shall only be affixed to the wall facing the public. It seems to me there are 3 different situations that we're running into. One is the US Post Office, where you're driving down Burlington and you're looking down and the frontage of the building is basically facing west. So that is what G is talking about here. Then you have the conventional situations we're talking about here with the distillery and Charlie's facilities, and that is facing the street. But there's yet another scenario, and that is when you're, and that is the second floor situations, where the door to the second floor may not be on the street, it may be down the alley, and that, you know, so that we're trying to cover that with separate wording on that. And I would say that that separate wording, rather than trying to talk about them as second stories, just simply say the entrance into the building, the facade or the wall of the building in which the entrance is made into the building to the establishment is one wall, or that if it's not a street wall, the option is to put it on the street wall so that the people have either choice. Now, we don't have that in this case with Charlie. Charlie's the street, the door is on the front, is on the street side. But I think it simplifies the wording considerably if we just forget about trying to differentiate with second floor and first floor and whatnot. The entrance into the building that people take to get to the establishment establishes the wall. If that's a street wall, fine. If it's a facade wall, or the front, or whatever it's called, the frontage wall, fine. But if it's yet another side wall, that is identified as the entrance wall. That might be a simpler way to word all this.
I think I would have to disagree, and I think that the word that option 2 states is good enough for us to start to figure out every single condition that sits in Riverside. The intent is that what we really wanted to do was make sure that these signs were visible, but yet they weren't far enough apart, and be it that he has multiple businesses in his building, and because it is an existing building and it has its architecture that obviously doesn't want to be changed, it makes sense to spread the signs out so people can actually see them. But I don't see any problem with option 2 with the way that it's written.
So just to clarify, H says such signs shall only be affixed to a wall facing a public street, except for second floor businesses, which may install a blade sign within 6 feet of the doorway serving said business. So if there is a side door that does not, or a rear door that does not face a public street, that a second story business could put their blade sign near that door rather than being forced to put it on the front of the building if they did not want to put it on the front of the building where their entrance is not there.
Except we're changing that, or we're anticipating.
Well, I'm not
changing
proposing to change that section. I'm still saying if they want to if their entrance
just
is not
allowing them
facing a
to do
street, it would need to be kept within 6 feet of that entrance. That seems reasonable to me to keep that in there, for one that does not meet the street, is not on a public facing street. I don't know that we need to change that unless the board unless the commission, I should say, thinks we do need to be looking at those instances as well. But I don't see that being as much of an issue as how things are looking on the front of the building and not looking crowded and making those allowances for the second story businesses.
So do we need to clarify H that the doorway serving the business is not on the street?
That's what it says. It says, they shall be affixed to a wall facing a public street, except second floor businesses which may install a blade sign within 6 feet of the doorway serving said business.
But it's not explicitly saying that that
Regardless of-
doorway is
Right.
not on the public street. So on the face of it, that would be at
So-
odds with G if we
Okay.
change G.
So it could read, such signs shall only be affixed to a wall facing a public street, except for second floor businesses, which may install a blade sign within 6 feet of the doorway serving said business that does not face a public street.
Sure.
Not located on a public street?
That is not located,
whether it faces a street or not,
so what, that is located?
No, it's not.
Is not located
which is not facing.
facing
Right, that does
a
not
public
face.
street. Is not located on a wall facing a public street? Maybe we're missing a word here.
I mean, I'm a little confused. When we go back to the post office example,
Mm-hmm.
that's a first floor business,
Right.
doesn't face a public street. So are they prohibited from having a blade sign because they're not facing a public street and they're on the first floor?
No, that's covered by the frontage in G. It's, the sign shall only be located on the frontage of the establishment.
Because it's on its own frontage, it would be allowed.
It's not facing the street, but it's on the front of that of the post office.
Right, but either G or H is gonna apply in a particular instance, whereas they're both written as,
Right.
That was the point I was trying to drive at.
right. So what if we combine G and H as like where signs are located?
So what G is trying to get at is you can only put the sign on your storefront.
Right.
Correct.
That's what that's trying to get across.
No matter where it's facing.
Exactly.
Well, it's also
Well,
stating it
because
has to
we
be
have the
within
next
6
one.
feet of the doorway also.
You know,
That's the big point that it's making, is that it has to be within 6 feet of the door.
so, but it's trying to make an allowance that a second floor business can have a blade sign not on its storefront, because we don't allow blade signs on the second story. They have to be on the first story. So they're not allowed to go above the cornice line, etc. So this G is supposed to tell you that you only get your blade sign on your storefront. You can't put it further down, but then it makes that allowance for the second floor businesses then to have that exception where they can put it on the first floor where it's not their storefront. Then you have H, which talks about that you're supposed to put them on a wall that faces the public street. So yes, I think when we get to H, then all of a sudden we are accepting out the post office from being able to have a blade sign. Mm-hmm.
So, so this doesn't really apply apparently to my condition, but, I'm just wondering when you own a building, it's logical that the person who has the store would like their sign in front of the storefront, and it's not particularly logical that they would want it somewhere else unless some condition would exist where they couldn't put it where they want it. So logic would define that it's going to be in front of the business. Now, I don't know if you have to specifically state that it must be in front of the business, because it pretty much will always be in front of the business. And I think we're kind of getting mired up in the language a little bit. If you just say you allow each business to have a blade sign and you determine that the distance between the signs is what it is, then I think you've got it. I mean, you've already determined the height, you've determined the projection from the building, and any more restrictions that you put on it in anticipation of different scenarios, I think you might have another applicant in a few months, years, probably more like years, come in here with another proposal like this, and they might be like, well, this just doesn't work for me. So I'm trying to just...
But see, this works to your condition, okay?
It
Your
does.
unique building, okay? Now, you can have a blade sign that has multiple tenants on it that is above a door if it didn't have a 9-foot cornice on it.
Right.
So you can actually have those blade signs be right at the doors, okay? You have a unique condition that you don't have the room, you don't have the head height room to put
you're
multiple
saying
signs. Stack them.
Yeah,
You have
so-
the ability to stack a sign
Got it.
that, because your building, because of the cornice and everything else, the architecture of it, you can't raise it up any higher,
Right.
okay? But if you could, let's just say that was another 3 feet up. You can easily design a sign that can say, Randall Architects and,
Got it.
what is the, No, I guess, the tutoring, I guess, right? And right below it, be right at the entrance. I mean, that would be something that actually could actually work on the village center because of the height.
Right.
So, I mean, you can do it. It's just that you just have a unique condition, and unfortunately, because Riverside is so unique,
Right.
every condition is different.
Every building's unique.
And so trying
So-
in trying to fix every single problem,
Right.
you're only creating
It's really
other
hard
problems.
to- Right, I understand.
But that's part of the reason why the very first application for blade signs, we wanted the city to talk about,
Right.
try to work out the bugs.
Right.
And that's the only reason I'm.
It's like reverse engineering it almost.
Yes.
Okay, so can we bring this discussion
Yeah,
back
second.
to the option? Thanks, thank you. Thanks, Charlie. So can we bring the discussion back to the two options that staff has proposed? One being no change, or two, as Sonia described it on page 2 of the staff memo. At this point, can I get a motion one way or the other with respect to
I'm
these
going to go
options?
with option 2.
Okay, do I have a second on option 2?
Second.
Okay, Sonia, can you please call the roll? Or any further discussion? Okay, Sonia, could you please call the roll?
Yes, give me 1 moment. Alrighty. Commissioner Gary,
Aye.
Commissioner Lesniak,
Yes.
Commissioner Mateo,
Aye.
Commissioner Mendoza,
Aye.
Commissioner Pelletier,
Aye.
Commissioner Commissioner Randall recused himself, Chairman Kuchera.
Aye. Okay, so that, Mike, Attorney Morris,
Go on, what were you gonna say?
I was simply going to acknowledge that the motion passed.
Okay. So now that we've done that, going back to H, does it serve any purpose, given the existence of G and the amendment you just made?
I think so, because, again, it's talking about the side of a building, so if for some reason your entrance is on the side of that building, and you wanted to put a blade sign up there, instead of putting it on the front of the building, that you have the option to put it on that other side door on the side of the building. That's what I think H was saying.
Okay.
I wasn't kind of confused about what it was saying. It was giving him the option to say, locate your sign here on the side of the building, because that's where your entrance is. You're walking up to the second floor, but that's your entrance.
That's what G says.
That's what G says, because that's the frontage of the establishment the sign
H
identifies.
says you can do it on the street.
You must do it on the street.
Actually, it says, yeah.
Should be fixed to wall facing a public street.
So if G says you're always gonna put it on the frontage of your establishment, what do we care whether it faces a public?
So I guess the H then is really more about that if it's not facing a public street, you're allowed to put it on that side.
G is the frontage. That's,
But
if you're
it
not
would-
on the post office works under G.
See, I look at the frontage of the building as being your entrance.
It's the frontage of the establishment. If you're on the side of the, where is your window? Where is your front door? If you have a window on the side of a building, that's the establishment
But I would not
frontage.
consider a side door a frontage.
Well, then so if the only entrance into a building, into an establishment is on the side wall, you're still saying the frontage is on the street. In that case, I
But that may
agree.
not be the only entrance to the establishment.
Well,
If you
the
have a
public-
second floor tenant, and his entrance is on the side, but the first floor tenant's entrance is on the front, that's where you can't have two frontages. So,
That's what I was arguing about. That's what I was
So-
saying.
if the second floor tenant has his door on the side, it's not the frontage. So he's gotta fall under H, where it gives him the exception to being on the public street.
Okay. Well, what about the post office?
That's his only entrance.
Yes, and it's not facing the street. so-
Correct.
But
It
that's
falls
his
under
frontage.
G.
That's his frontage.
That is his frontage.
I think what Commissioner Gary is getting hung up on is that it says such signs shall only be affixed to a wall facing a public street. And that applies to everybody. And I think that's where Commissioner Gary is getting hung up on.
And that any sign shall only be located on the frontage of the establishment in the item above. So if the post office wants to put something in there, where do they put it? Do they put it facing the lot, the parking lot, or do they put it on the front of the building? Either way, they're gonna violate either G or H, because both of them are shall. They're not can.
Correct. So I think we have found an instance where the post office would not be able to have a blade sign.
Or you give the post office a choice of where they want to put it. I mean, I can see, well,
And I guess the other one would be there's the dietitian in that building as well,
On the other side.
on the other side. Now, we've made allowances, I believe, in the code for a wall sign. You can have your wall sign or your window sign. There's other language in there that says that your frontage is facing can be facing a public parking lot or alley, or it's facing a public street. So the wording is a little bit more broad, I think, for those signages than perhaps what we alluded to here in blade signs.
So what if it's, such signs will only be located on the frontage of the establishment that the sign identifies, except in cases where an establishment does not face a public street, in which case they have a choice of locating it on the wall facing a public street.
Or by their doorway.
Or by their.
Right, so they could put it
or
on the
by their
front,
entrance
or
way.
if they don't face onto a public street, they could instead put it on the public street side.
I'm sorry, they can put it on the public street if they choose, or they can put it around the corner in front of their, yes, that's exactly my point, precisely my point.
So let's not, we don't have to quibble over the exact wording, but we can rewrite that section when we bring it to the board so that it's not two things and you can't satisfy, if you don't satisfy one, you're not going to satisfy the other in certain cases. We're going to set it up as an alternative. Is everyone?
Is
So
everybody
this-
agree with that?
So in this case, the dietitian could put a blade sign right underneath Arcade Jewelers' sign?
I mean, isn't that the intent of,
It's supposed to be 6-foot spacing between signs.
But my point being,
that would look weird?
the owner wouldn't like it. And it would look weird.
Okay.
Yeah. It's a hypothetical.
So the post
Now, when you,
office
when
might
you
just
say, Jill, when you say below his sign, are you talking about the sign being designed as one complete package or two individual separate signs?
You're giving me credit for thinking more than I have. I was just thinking out loud.
If you had a blade sign for the post office and one for the dietitian facing Burlington, coming out from Arcade Jewelers, would that look weird?
If it was, it would depend on how the sign was designed.
But wouldn't it also misdirect for people who didn't know that the dietitian is not where the jewelry store is?
If it probably misdirected them that much, they probably, I'm surprised they even got to where they were at.
Well,
I tell you, when I went to visit your office, I came and that's the right address, where in the hell is this thing? Just, if a blade sign were out there, I'd know for sure I'm in the right place, I just gotta find my way in, and there's only one door, so I'd go in. But I really had trouble finding your office, and was wandering around, looking around and everything, and finally I decided to come in, and that's when I saw the sign on the wall inside. And I think people will do that. If they see the blade sign there, in the confines of the sidewalk, they know they're in the right place, they're gonna find the door. And the way Charlie has laid these things out, the signs in regular order, it just, to me, it's fantastic, it's great, it's come hither, this is the area you wanna come to, there's lots of activity here, and it's It's just a beautiful thing that he's done.
Okay, so we have approved language that resolves the issue at 39 Quincy, correct?
Mhm.
And now the question becomes, do we want to direct staff to further revise G and H to address the issue that we're talking about, which I think it sounds like,
Tenants on the first floor that don't face a public street.
yeah, and it sounds like we would be, let me answer this question. Would we be comfortable offering the dietitian and the post office an opportunity to have a blade sign coming out from near where their doors are, within 6 feet of their doors, on the east and west side of that building?
Or on the street.
Or on the street?
With the
Within
owners.
6 feet of their door.
Yeah, frankly, I'm more comfortable within 6 feet of the door, which would take it out of play from being on the side, which would remove the option of having it face Burlington.
In which case you don't need H. Because the blade sign would only be wherever the frontage is, correct?
Correct.
Right.
So we could just get rid of
So it
H
becomes a question of
altogether.
just striking H. And I would be comfortable with that.
All right.
That sounds like the way to go.
No, I vote against that. I still want the street. I want the people to have, who are on the side, to have the option of in front of their door or on the street. So.
But then we get into a thing to say, how close can the signs
If it can
be
meet the
together?
6 foot separate.
So then there would have to still be some type of separation.
Well, we still have that on
There
there.
is
No
6
two
feet
blade
down.
signs can be closer than 6 feet.
So then
That's
that's
But
fine.
in the case of that building, arcade is not, it's not a blade sign.
No, I understand.
No, but
So then
basically,
you have to get 6 feet.
what I don't
between-
wanna do is have 8 signs on the front of a building, because 4 of them are on the side. Because do you have enough space in between them? I mean, that's what, we're looking at when we're looking at 39 East Quincy, is spreading them out, because because by the requirement of being next to the door, it doesn't work. But on the other hand, where we do have the ability to say, put the sign by your door when you have the opportunity, why would we suggest then another opportunity to put it on the front of the building,
Right.
other side of the building?
I wouldn't say that, if you're pulling into the parking lot to get to that particular building, you're going to see the blade sign coming out from a door, and it's gonna help direct you. If you're on the sidewalk walking, you will probably notice, as you're walking up to the one side, a blade sign coming out. You're not gonna see one, obviously, on the other side of the building, but I suppose if you're looking on that side and you don't see the sign you're looking for, you walk past the front, you don't see the business you're looking for. You walk past, maybe you're gonna look around the corner, and you'll see the blade sign sticking out of the side of the building, near the door on the east side of the building. So, I don't necessarily know that you have to have one facing the street, or that it's on the street to be visible. I'm trying to think of other buildings that this could pertain to. I mean, I suppose you're looking at the narrower, deeper buildings, so you're looking at like a PNC Bank, if that were to be divided into multiple units, or perhaps
Doesn't
an
the
Oakley
Coveney
building.
Lane have somebody in the
Oakley
back?
Lane building.
Doesn't it have somebody in the back?
Doesn't have anybody in there right now.
Well.
But I think it does have a back door and then, no, well, I think it's a side
Side
door,
door, I
towards the
thought.
back, but at the back. And then they've got their front door. So that could be divided into 2 units, and one has the access from the side door at the back, the back half unit, and the front half unit would have their access from the front.
Don't forget, there are 2 scenarios for when a sign is useful. There's a sign when you know where you're going and you're looking for a specific property, and the scenario you just discussed is absolutely true. The other scenario is you're just wandering down the street and you're looking at, having a good afternoon and looking around, and you don't know what's available. But if there are signs down the street, you're not as likely to see those as opposed to a sign out that's over the sidewalk.
But if you're wandering around, isn't the word wandering meaning that you're kind of walking across and oh gee, there's a building with four tenants on the side of it?
Okay, I'm going to suggest that, we're not going to, this evening, reach any kind of consensus on this. We have the language that we need to address item 8B on the agenda. Let's deal with let's continue this discussion at a point where we need to discuss it. Next time the post office and the dietitian wants to have a sign, we'll continue the discussion.
Works for me.
So, Sonia, Michael, are you comfortable with proceeding with the change we made to G and leaving H? Is that?
I thought we were eliminating H.
Striking it.
Well, I guess that's the point of contention.
Well,
One commissioner does not seem to be in favor of eliminating H.
At a minimum.
Nobody else has really quite weighed in on that, so.
in a minimum, I think we need to change G and H's from shall to can or something to that effect, because you can't have shall in both cases. There's no way to comply. Shall means absolute must, I believe, doesn't it?
Yes, this would say that they can only be affixed to a wall facing a public street.
So
So as it stands,
Right, so
somebody who
that's,
does
that's
not
what
face a
caught my
public
eye
street would not
originally.
be allowed to have a blade sign,
Yes.
unless they're a second floor business, because we have made an exception for those. So do we feel we need to address that at this point?
actually, we could just leave it and sort it out when an application comes in that does want to do something different.
That's
Attorney Mars,
I think that's where the chair was going, and I think
Yeah.
that's fine.
that's acceptable?
Yep.
Okay.
I think we're good. So, we approved under 8C the motion. Now let's go back to 8B and revisit the question with respect to the property at 39 East Quincy. Staff has put forth a recommendation that we approve the proposed signs as proposed by the applicant. And we now have language that permits that.
We
So-
will, once it's approved by the board.
Once it's approved by the board. So as a procedural question, I think I know the answer, but Attorney Morris, can we proceed?
Yes, so the motion would be to recommend approval of the proposed blade sign permits for 39 East Quincy, subject to board approval of the proposed text amendment.
Would you want to say, because there's two of them, there's two plans, wouldn't you want to say it for the proposed plan of the
Preferred?
of the owner, the preferred plan of the owner?
Mhm.
Because you need to be able to state something.
Perfect.
Okay, so do I have a motion to that effect?
So move.
Okay.
Second.
Sonia, would you kindly take the roll?
Yes, Commissioner Gary,
Aye.
Commissioner Lesniak,
Yes.
Commissioner Mateo,
Aye.
Commissioner Mendoza,
Yes.
Commissioner Pelletier,
Aye.
Chairman Kuchera.
Yes. Okay, thank you. Sorry about that. That's the clue that we're running long, and we still have a public hearing and other matters to address. Okay, so let's recalibrate here. All right, so, thanks, Charlie.
Finally.
Now you see why.
All right, so I guess,
Back to the public hearing?
yes, I guess the question becomes, in terms of priority, do both of those matters, must both of those matters be addressed this evening?
Subdivisions definitely needs to be addressed this evening, because we do have a moratorium deadline that we're coming up against. Double frontage lots, I would like to get that looked at this month, because I do have a pending permit, pending the outcome of this discussion. So if we do have to put it off a whole month, then that puts them off a whole month before I can issue the permit for that. And with spring coming, I'm sure people are anxious to get started on it.
Okay, so those are the two remaining items we
Yes.
have, correct? The public hearing for PZ 16003, the text amendment regarding double frontage lots, encroachments, and subdivisions, yes? Okay.
Yes.
All right, do I have a motion to open a public hearing with respect to a text amendment regarding permitted encroachments for double fronted lots?
So moved.
Second?
Second.
All in favor? All opposed? let's open that public hearing for agenda item 7C. So, first read the notice of public hearing. A notice is hereby given to all interested persons that a public hearing before the Planning and Zoning Commission of the Village of Riverside will be held on Wednesday, February 24th, 2016, to consider proposed text amendments to the Village of Riverside zoning ordinance. This regards application number PZ 16-003. The petitioner is Village of Riverside. We're talking about a proposed text amendments to sections 10-7-4 permitted encroachments. And I think that's sufficient summary of what we're talking about. Sonia, would you kindly introduce the
Yes.
amendment?
During a review of a building permit, staff discovered that although there is an exception for double frontage lots for fences and decks, there are no exceptions for any other types of structures. Staff believes the zoning ordinance needs to be amended to address double frontage lots more thoroughly in regards to accessory structures and appurtenances. The definition of a double frontage lot in our zoning ordinance is a lot having frontage on two non-intersecting streets as distinguished from a corner lot. The zoning ordinance does not differentiate double frontage lots in the method for measuring street yards. The minimum street yard on each lot shall be measured from the closest point of the existing principal building line, which includes the eaves, to the street line. In the site development standards, double frontage lots are addressed specifically for decks and indirectly for fences, but no other exceptions are made for double frontage lots. For decks, it says, for double frontage lots, decks are prohibited in the street yard or front yard where the front entrance of the building is located. For double frontage lots, decks are permitted at the rear of the building but must meet setback requirements. And then for fences, it says, fences and walls shall be prohibited in street yards, except where the street yard adjoins a non-residential use or along 26th Street, 31st Street, or York Road, subject to further review by the village staff. Along street yards that adjoin 26th Street, 31st Street, or York Road, a fence shall not exceed 6 feet in height. And then it goes on to say, in situations where the street yards of adjoining lots are of different dimensions, no fence is allowed in the street yard of either property. Thus, a fence in either side yard shall be bound by the dimensions of the deeper side yard. Similarly, in the case of corner lots, the rear yard fence of the corner lot is not allowed to extend into the street yard of the adjoining property. So, in the case of a double frontage lot, the minimum street yard for both streets, so they have 2 street yards as a double frontage lot. So their required setback is exactly where the house is. Those are their setbacks. Those are their required street yards. So if they're 15 feet back from street A, that's their required street yard. If they're 120 feet setback from street B, that is their required street yard on that side. And the only encroachments that are allowed into those street yards are as shown in the street yard section of the permitted encroachments. So, staff has prepared a text amendment for consideration that would provide an exception to street yard encroachments for double frontage lots. It would be added as a footnote to street yards. So we'd have a little footnote where it says street yards, and then the note would be underneath, and it would say, in cases of double frontage lots, the type of encroachment on the rear of the building shall be regulated as a rear yard encroachment. In no case, however, shall the rear yard encroachment on a double frontage lot be allowed to extend into the street yard of the adjoining property if the front entrance of the principal structure on the adjoining property is located in the street yard opposite of the front entrance of the subject property. So as I said, that would be added as a footnote to Table 7 for front yard and corner, side yard, or street yard. Permitted encroachments, so this would allow chimneys, arbors, trellises, pergolas, mechanical equipment, water gardens, and accessory buildings to be built behind the house, but would restrict them from being placed any closer to the street, to the rear, than any other adjacent houses that face that street. So if they do happen to have a house that faces the street that they don't face, they would not be allowed to put anything in that yard that would be any closer to the street than that adjacent house that faces the opposite street. So that's how that reads. Staff is also proposing to revise the table related to balconies, because adding the footnote would still not allow a balcony deeper than 2 feet on the rear of a house on a double frontage lot. The proposed change would allow balconies to encroach 5 feet into a required rear yard. This, combined with the footnote regarding double frontage lots, would allow a maximum 5-foot deep balcony on the rear of a home on a double frontage lot. So that would be, type of encroachment would now just say balconies, and then under street yards, it would say, yes, no more than 24 inches into the required yard. For interior side yard, it would say, yes, but no more than 24 inches into the required yard. And then for rear yard, it would say, yes, no more than 5 feet into the required yard. So that change combined with the footnote then would allow a house that's on a double frontage lot to have a maximum 5-foot deep balcony on the rear of their house. Staff has prepared some maps of the various areas that there are double frontage lots throughout the village for your reference. Again, this is a text amendment to the zoning ordinance, so the preservation ordinance states that all proposed amendments to the zoning ordinance must be submitted to the Preservation Commission for review and comment as to the effect of the proposal on the historic landmark designation of the village or the general plan of Riverside. So these comments are supposed to be submitted to the village board for review. So the Preservation Commission will be holding a special meeting within 30 days to review these amendments as well and provide their comments to the village board along with your recommendation.
Do we have many of these lots?
So we have, I guess, more than you would think. So you have Northgate.
There's several maps in here.
So you have the houses that are on Shenstone and Blythe that back up to York. You have one lot that's on Shenstone that is just a little bit past Blythe, that is a through lot to Blythe. You have, like I said, along Northgate that backs up to 26th Street. You have Maplewood that backs up to 26th Street, as well as Maplewood on the south side that backs up to Park Place. You have a lot on Woodside. You have, oddly enough, the lots on Lionel that back up to Haas. So where the cul-de-sac is, there are a couple of lots that back up to a public street. So
Probably no more than 50.
So it's not a lot, and then you have along Selborne as well, and back up to 26th Street. So we have a few areas. We have Kent, those are through lots to Lindbergh. So those are the few areas where it does occur. And in a few of those areas, you do have the situations where they have a house opposite of them that faces the opposite street. So that's why I felt it was important to make sure we had that restriction, that they couldn't put then anything in their rear yard that would then encroach into that established front yard of the house neighboring behind them. So that way somebody's not putting their pool there or putting a water garden there or something along those lines.
I think we have a typo on page 2 of the proposed text amendment.
Okay.
It shows 24 inches, 24 inches, 24 inches. The last one should be 5 feet.
Oh, goodness, yes. Thank you for catching that.
I'm sorry, Dennis, I was reading something.
Page 2 of the markup, where the tables, the red markups, they say no more than 24 inches, 24 inches. The third one says 24 inches, but it should be 5 feet.
That's right, it should be 5 feet. I apologize for that. So I did include the entire table so that you could see all of the permitted encroachments, and so you could kind of compare in a rear yard where those encroachments are allowed versus in a street yard where they're not allowed. commissioners don't have any comments, should we open it up to the public, see if they have any comments?
Yes, please.
Is there anybody in the audience that wishes to comment? No? Okay.
Okay, then do I have a motion to close this part of the public hearing?
So moved.
Second.
All in favor?
Aye.
Oh, okay. All opposed? Passed, okay. All right, so let's open it up for some discussion then. So I'm looking at page 2 of the memo with the proposed language in paragraph 6. And I'm having a hard time visualizing, maybe, I don't know whether it's just a long day or maybe I'm just being too left-brainish, maybe a picture would help. I'm trying to understand some of the language after the if. If the front entrance of the principal structure on the adjoining property, so I get that part, is located in the street yard opposite of the front entrance of the subject property.
Faces the other street.
So if it faces the other street. So I guess a good example of it would be if you go to area
Woodside.
3, which shows the lot on Woodside that goes through to Kimbark.
Yep.
You can see that the adjacent house to the south, 67 Kimbark, the front setback of that would then be extended across 74 Woodside, so nothing could encroach into that street yard along Kimbark, as established by the adjoining neighbor, because they face Kimbark versus facing Woodside, which the front of the house does.
So it
So
prevents, say, a pool from being built
Right there.
which would be
Okay.
in the
There is a
front yard.
There's a pre-existing condition which violates that.
Right, they have a detached garage that currently extends into that required yard, although,
So that would apply to the fences, the garages, pools, any features that would typically be in the backyard couldn't encroach in front of number 67.
Yes,
exactly.
exactly. So
So
without
that would still
going,
maintain that front yard.
so would we be making that a legally non-conforming?
It's already non-conforming, because it's in the street yard. So, right now, it's not allowed, it would still be not allowed.
So right now, the whole street.
Might be a little bit
So if
less.
we look at the opposite page,
Yeah.
I didn't realize this before, but on Haas Avenue, we've got 3710, the front yard, the street yard, projected up into 291, basically slits the whole backyard in half.
I think your street yard is parallel with, it's supposed to follow your street, so I think it would arc. Although the right-of-way is squared off there, isn't it? It's not curved. I apologize. That's a mistake on my part. That is squared off, so.
Don't anybody buy 291 Lionel, I guess.
295. It's a long pergola covered.
Well, the required
295
yard
even-
is
No, 295 isn't next door.
291.
3710 is next door to 291.
Hmm. I suppose there's always the variance process.
Exactly.
When you have unique situations.
Well, that's what the
It's
variance
different.
process
That's
is
what
for.
the variance
That's
process
exactly
is
what it's
for.
for.
That's exactly what it's for. That's a hardship.
It is.
Okay, so is there any further discussion or questions for Sonia with respect, or Attorney Mars with respect to the proposed text amendment? If not, then may I hear a motion?
I do have a question, sorry. The change to the balcony for, it seems like we're making that change for all rear yards, not just that it would apply to all.
Right, and I think in most cases, you're not really gonna ever come again up to that
Seeming-
issue.
seemingly, yep.
But even if you do, the rear yard is 25% of the
Yeah.
depth of the lot. So this would be a 5-foot encroachment into that 25% at the most. So you still would have a significant, presumably a significant amount of space there as well. Most houses in town have a much larger setback than the 25%, but you have the few areas where you have only the 5,000 square foot lots or 6,000 square foot lots where they are a little narrower and are probably right up against that setback line.
There's also the one house on Herrick that's pushed all the way back to the rear lot line, just next door to, forget their names, on the natural health place.
Brand.
Yeah.
Yes.
Okay, I just wanted to clarify that.
So I think we definitely want to restrict it to only 24 inches for interior side yards. I can see similar for, your normal street yard. You don't want something projecting that far out in front. But in the rear, it seemed like that would be an acceptable place. And there are a lot of other communities that have balconies as a maximum 5-foot encroachment. I don't know, how deep can you do a balcony before it starts to not necessarily, starts to require a post as opposed to just being cantilevered?
Depends on how far you want to go back into the house.
Well, it depends on whether you bracket it back to the house. And, you could bracket it back and it'd still be a balcony.
That's true.
But your 5 foot is more than sufficient.
I felt that was generous enough to make it a seating area without being excessive, but 24 inches is a itty bitty to have on the back of your house. That seems
What was that
a little bit
cantilever
overly
we stood
restrictive.
over Lake Michigan? About 30 feet.
Okay,
I
so,
have a question.
yes.
Sonia, the table,
Yes?
1074, the column heading front yard and corner, side yard or street yard, the 2 superscript, that's new, right?
Yes,
So that
that's
should
the
be
new
read?
footnote that brings you, that's the new footnote. So for street yards, you then go down and look at,
So when this goes to the board, can you make that red?
is it not red on there? Oh, you know what? It was the only red thing on the page, and when it's that small, sometimes the scanner doesn't pick it up. So, but I will try to make sure that that comes out red. Maybe I'll put something else red or color on there. Make sure it picks it up.
Move to accept the text change.
Second.
With his correction.
With
that it's
the correction of
foot.
the 5 foot.
Correct,
And the red.
and the red.
On the red. Got
Okay.
the red.
Sonia, would you kindly call the roll?
I'm sorry, could you remind me who seconded? Alrighty. Oops, sorry, I'm writing it down on the wrong one. All right, Commissioner Mateo,
Aye.
Commissioner Mendoza,
Yes.
Commissioner Pelletier,
Yes.
Commissioner Randall,
Aye.
Commissioner Gary,
Yes.
Commissioner Lesniak,
Yes.
Chairman Kuchera.
Yes. Okay, motion passes.
Thank you.
Thank you. Okay, then if we can kindly move to the discussion of subdivisions, which was agenda item number 6. You may recall this is a topic that we have treated or discussed 3 meetings now?
Yep,
That
this
was
will be our third meeting.
disgust or disgust?
It was discussed and proposed changes were gone through, so Sonia, would you kindly bring us up to date and help
Yes.
us understand
so-
what you're asking us to do this evening?
We have taken your comments from the January 27th meeting and incorporated them into the draft text amendment for subdivision regulations and the preservation ordinance. So the biggest one would be the addition of the general plan definition. So that has been added to both the preservation ordinance as well as the subdivision regulations. And then that now references the plan that's actually Exhibit A in the preservation ordinance. So the definition is, let's get to that page. The plan designed by Frederick Law Olmsted in collaboration with Calvert Lowe and Olmsted Bow and Company in 1869, set forth in section 11-1-5, Appendix A of this chapter. So that is the definition that's been added. We are proposing to update the picture of the plan because the one in the code is not exactly legible. So we're going to try and replace that picture with a clearer one that we have.
What does that picture show? Does it show lot dimensions? Does it show setbacks? So what are we looking at?
It just kind of shows, well, basically it's showing the curvilinear design and the parks. I mean, that's the primary thing that it's showing.
I know it, but it's not showing anything. It's a nice, pretty picture, I guess.
And that's the issue with the general plan, yes, but it is something that is part of what our designation is the preservation of that curvilinear streets of the parkways that were shown on there. So that is why the reference continues. So, and it does show that all the lots are larger, and that's why we reference the general plan's preference for larger lots in the Preservation Commission's review as well as the subdivision regulation review.
But how do we then determine subdivisions off something that has no dimensions?
It's a guiding document. So it's not the only thing you look at, but it is a guiding document that you have as a tool in your review. So the other changes that were made were regarding the addition of historic locally landmarked houses as items that are to continue to be preserved to the maximum degree possible as one of the requirements for subdivision. So that was added in there, as well as the protection, preservation of trees. So that language was also added in as a requirement for subdivision. So it says the subdivision shall preserve large existing trees wherever possible due to their value in soil conservation, health, and community appearance. And then in conjunction with that, we added that the location, size, and species of all deciduous trees located on the parcel with a trunk size of 4 inches or greater in diameter measured 1 foot above the natural ground level. All multi-stem trees greater than 6 feet in height with an aggregate trunk diameter of 10 inches or greater measured diameter at breast height, and all evergreen trees measuring 5 feet or greater in height shall be shown on the plat of survey that they are required to submit along with the application for subdivision.
So in the optimum word is wherever possible, meaning that, again, I didn't like this from the get-go about the whole thing about trees. I think I'm more concerned about what the house looks like than saving a tree. I'd rather have a house that looks nice versus a tree that happened to be there and someone doesn't want to tear down because it's it's 18 inches in diameter. So does this code restrict them from tearing down that, or it's just saying you may want to think about it? But if I was subdividing a lot and there was a tree that was in the way of what I wanted to do, do I have to save the tree or can I tear it down?
So I think we have the wherever possible that says that it could be torn down, but I think you're going to have the opportunity to give it a bit more scrutiny. If you see that there's a large tree located where you think would be the building pad or very close to a building pad, you can say, are you planning on preserving that tree? Or we want you to preserve that tree because it's an 18-inch oak in good condition.
Where is that wherever possible stated?
That is going to be on page 4 of the subdivision regulations, letter F. And then the requirements for them showing the location, size, and species is on page 6, number 7.
Are those dimensions in 7 on page 6, are those fairly common? Seems to me there's a couple of lots where we are that, man, there are gonna be 20, 30 trees in the backyard that are 4 inches or greater. Is that a common?
4 inch and greater actually is a common tree to almost be planted in a commercial development from the get-go.
Okay.
Okay, so
So that,
it's a relatively small tree. In terms of life, it's probably got about 6 years in it, depending on the type of tree it is. Oaks, it would be a lot larger, but most likely an oak that's 4 inches in diameter isn't gonna survive transplant if it's four inches.
so this could be one heck of a lot of trees.
If we want to, I mean, this is at least identifying them.
Right, that's all.
You know,
that
so
we're
we're asking
requiring
them to
is-
identify these trees, and then we're saying that you're going to preserve large existing trees. A 4-inch tree isn't necessarily a large tree. But
And they're
this
required
is
to-
then requiring them to, you know, this is not a sapling that's accidentally growing in their property. It's a, you know, a 4-inch caliber tree is a tree, you know, it's, you know, a 5-foot tall evergreen, 6-foot tall evergreen tree is a tree, it's not a little.
Are they required to have an arborist do this, or are they doing this on their own to say, you know, I think it's X and Y? What's the requirement of who identifies these things?
We didn't specify that, so it could
Right,
be
I-
a surveyor.
I would guess the idea would be that, you know, whoever's doing your plat of subdivision, is gonna have a different level where they're also showing a survey of your property with the structures on there, which aren't gonna be on the plat. And on that, they would also put little ticks where these different trees were.
And now
But
they would be
it's gotta be-
required to identify them, which would probably mean that they would have to hire an arborist or somebody to identify them. Although it doesn't explicitly say down there.
You've got to survey each tree and identify it by size and species.
In a number
Doesn't
of,
seem onerous to me.
I don't think so either. In a number of the villages we do work in, we're required to send a tree survey anyway with the civil documents. So that they actually have ordinances of tree replacement, so.
We don't require.
I know we don't require that, but the fact that it would be nice to know what's being taken down. Which brings me to, one of the things I thought was kind of left out in F was their importance isn't just soil conservation, but energy conservation as well. In the case of summers, they provide a lot of shade, which will reduce, you know, cooling loads on a house. So that's why we preserve the 48-inch and the 32-inch elms that are in our backyard at about $1,200 every 2 years. So, because I'm sure we're getting that much in savings given the lack of insulation in our home. So.
So that being said, I do think maybe the language of F is a little strong, just because we are saying shall, which is an absolute requirement.
We could change that to
Preserve
should.
large existing, which we don't necessarily identify what large is, and wherever possible. You know, that's a fairly high bar, isn't it, to say wherever possible? For the most part, it's always possible. You know what I mean? There's always a way where there's enough money.
Sure.
So.
I would imagine if we're going to recommend to the board a subdivision favorably, we could also recommend conditions that this, and this tree be saved. There aren't going to be that many subdivision requests, I don't think.
Right, yes.
Hope I didn't just jinx us.
So can we soften it by changing shall to should?
Yeah.
Yeah,
I'd like to request another comma.
That's,
Where am I
That's
missing?
500.
485,
Comma for 500.
485,
A.
A.
It just tripped me up in reading. It's not a required one, but impact the village's National Historic Landmark designation, comma, And subdivisions that are contrary, since it's a separate clause.
Maybe a semicolon.
Writer's choice.
Going back to F, Commissioner Randall had suggested, I think, adding energy conservation, maybe after soil conservation. Is everyone good with that?
Yes.
Okay.
I would like in E, just to add that no subdivision should be approved that will negatively impact historic sites, landmarks. Instead of protect to the maximum, I just. So it would read similar to A.
So no subdivision.
No subdivision should be approved that, or shall be approved, that will negatively impact historic sites, landmarks listed in section such and such, scenic points, desirable natural areas, and other environmentally sensitive features.
So you're looking to be more restrictive on that particular
Yes.
item, and for all of those items.
Now, do we have historic sites defined well enough?
Well,
actually,
landmark
it's-
sites are a function of the preservation. You can have landmark structures, buildings, and sites. So a site might be, it doesn't have to necessarily be a home, it could be where something significant happened. I don't know if we have any landmark sites
No, we don't.
in the village currently, but.
Under the
scenic
shall,
points?
we're also including desirable natural areas and other environmentally sensitive features worthy of continued preservation. And those shall be, no subdivision
Those
shall
shall
be
not be
approved.
negatively impacted.
I guess my biggest concern is the landmarks.
Is what?
The landmarks listed.
Are scenic points defined anywhere, or is that
No.
subjective?
Subjective.
Because I think the argument could be made, if you're gonna subdivide a lot and you put up another house, you have altered the scenic points.
Could be. So perhaps we separate it out and have protect to the maximum degree possible as we had it before, not include, it does not say landmarks listed in 11.15 Appendix D, and move that to a separate point that says no subdivision shall negatively impact.
No subdivision should be approved that will negatively impact the landmark.
A national-
The landmark.
Well, what if we
the
just
land-
move landmarks to A?
Yeah.
We could do that.
Impact the village's national historic landmark designation and designated landmarks. And that way we could just leave the maximum degree possible applying to the rest.
Yeah.
Let's see, what was the
You
other?
would refer to section 11.15.
Yes. Yeah.
We would just
Move
pull
that
that exact
phrase.
language and
Right.
move it over into A. I guess the other thing to discuss would be that we had talked about allowing an administrative review of minor subdivisions at the last meeting, and you asked staff to draft some language that would be very narrow in scope. So the idea was that we would allow it where no new buildable lot is being created by the swap of land. However, as Attorney Mars and I were working on trying to craft some language that would be very limited, it became very difficult to try to cover every possible situation when you start to get into consolidations and the like that you still wanted to be able to see. So we decided that it would really not be possible to kind of write that language into there and do it well. So we're no longer recommending adding that administrative review and approval of a minor subdivision. And so we did not include that language.
So everything remains coming to us.
Yes, so
Right.
everything would come to you.
It wasn't gonna provide much of a benefit, and it doesn't seem like a huge imposition for somebody to come here and knowing that it's minor, it's probably gonna be pretty quickly.
So,
Okay.
My equivalent of a comma is removing the second $3,000 on page 7. Generally, aerospace industry likes to put a number in once. If you put it in twice, there's a chance you may edit, change one number later, and then you have conflicting numbers. On page 7 down the bottom, you can just remove the second 3,000.
So just say if consultant fees or recording fees exceed the application fee?
Yes.
Okay.
And also, this is all minor stuff. On page 8 at the very top, the partial paragraph at the top, the last 4 words, being so subdivided into 2 or more parts. Well, we're also including consolidation, so I think we can just drop those last 5 words.
no approval shall be given unless such map or plat shall be signed by the owners of the entire property being subdivided.
Actually, it should be properties in parentheses. Property with IES in parentheses, perhaps.
Sonia, I'd like to still go back to page 6, item 7, which talks about these trees and change 4 inches in diameter to 8 inches.
Here.
I think a 4-inch tree is way too small. And I also think a 5-foot evergreen is too small. I would say 10 foot.
Okay.
I mean, I can buy a 5-foot evergreen from Home Depot for $20. So I would make those changes. The other one, I'm not really sure, measuring the diameter of a multi-stem trunk, if it really matters or not. But
So are you okay with the
I'd hate to
comments?
have a guy have to go and survey 20 trees on his lot because he has a bunch of weed trees that are 4 inches in diameter.
Okay.
So if it's an 8-inch tree or a 10-foot evergreen, yeah, fine.
Do we want to increase the multi-stemmed ones to 10 feet as well then? Can we
Sure.
get 6 inches, or 6 feet
feet
height?
doesn't seem very high.
What?
6 feet does not seem very high. I would change that to either 10 or 12.
Let's double check if there's nothing else that I missed. Going over here. Now, the Preservation Commission reviewed the proposed revisions at their February meeting and recommended approval of the proposed amendments. So at this point, we are looking for you to make your recommendation to the village board for them to vote on at their next meeting, as the moratorium is expiring at the beginning of March. So,
So do I hear a motion to approve the proposed text amendment as we have amended it this evening?
So moved.
Second.
Sonia, would you kindly call the roll?
Certainly. Commissioner Randall?
Aye.
Commissioner Gary?
Aye.
Commissioner Lesniak?
Yes.
Commissioner Mateo?
Aye.
Commissioner Mendoza?
Yes.
Commissioner Pelletier?
Yes.
Chairman Kuchera?
Yes.
Motion passes.
Consensus out of exhaustion.
Okay.
Thank you all very much for your diligence in this.
Can I make a motion that we adjourn?
Plowing through
Second.
everything here on the agenda with me.
Thank you, Sonia and Michael, for preparing us for this evening and reconvene on the 23rd. I heard a motion, I heard a second. All in favor of adjournment?
Aye.
Any opposed?